the Chief Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the Court is now in session.
The Clerk of Court will please call the matter at hand.
Called for continuation of oral arguments are the cases in GR number 204819, James Imbong versus Lovely Ann Imbong for themselves and in behalf of their minor children, Lucia Carlos Imbong and Bernadette Carlos Imbong, and Magnificat Child Development Center Incorporated versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 204934, Alliance for the Family Foundation of the Philippines Incorporated, represented by its President, Maria Concepcion Noche et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 204957, Task Force for Family and Life Visayas Incorporated, and Valeriano S. Avila versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 204988, Serve Life Cagayan de Oro City Incorporated, represented by Dr. Nestor Lumicao, MD, as President and in his personal capacity et al. Versus Office of the President et al. GR number 205003, Expedito Bugarin Jr. versus Office of the President of the Republic of the Philippines et al. GR number 205043, Eduardo Olaguer and Catholic Cyberspace Apostolate of the Philippines versus DOH Secretary Enrique Tiona et al. GR number 205138, Philippine Alliance of Ex-Seminarians Incorporated et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 205478, Reynaldo A. Chavez, MD et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 205491, Spouses Francisco S. Tatad and Maria Feni Tatad et al. Versus Office of the President of the Republic of the Philippines. GR number 205720, Pro-Life Philippines Foundation Incorporated et al. Versus Office of the President et al. GR number 206355, Millennium Saint Foundation Incorporated et al. Versus Office of the President et al. GR number 207111, John Walter Huwat et al. Versus Honorable Paquito N. Ochoa Jr., Executive Secretary et al. GR number 207172, Couples for Christ Foundation et al. Versus Paquito N. Ochoa Jr., Executive Secretary et al. And GR number 207563, Almarim Senti Tila et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. Appearing as counsels for petitioners in GR number 204819 and 207111 are the following: Attorney James Imbong, Attorney Joe Aurea Imbong. For petitioners in GR number 204934, appearing are Attorney Maria Concepcion S. Noche and Attorney Fides Angeli Sabio. For petitioners in GR number 204957, Attorney Maquilito B. Mahinay is appearing. For petitioners in GR number 204988, there is no appearance. For petitioner in GR number 205003, there is likewise no appearance. For petitioners in GR number 205043, no appearance. For petitioners in GR number 205138, Attorney Ricardo M. Ribo and Attorney Lino E.A. Dumas. For petitioners in GR number 205478, Attorney Howard M. Calleja. For petitioners in GR number 205491, Honorable Francisco S. Tatad and Attorney Alan F. Pagia. For petitioners in GR number 205720, Attorney Rufino L. Policarpio III. For petitioners in GR number 206355, no appearance. For petitioners in GR number 207172, Attorney Luis Francis Rodrigo and Attorney Luisito V. Liban. For petitioners in GR number 207563, Attorney Luis Maria Gil Gana. For petitioner in intervention, Samson S. Alcantara, no appearance. For petitioner in intervention, Buhay Party List, no appearance. For the public respondents, Honorable Edsel C. Lagman, Assistant Solicitor General Hermes L. Ocampo, Assistant Solicitor General Mirna N. Agno Canuto, Assistant Solicitor General Derek Portoliano, Senior State Solicitor Jonathan de la Vega, Senior State Solicitor Florin Hilbay, State Solicitor Maria Sofia Obieta Palad, Associate Solicitor Maria Cristina T. Navarro, Associate Solicitor to Ivan Mark Ladores, Associate Solicitor Leia Teresa Labadan, Associate Solicitor Maximo Sison, and Attorney Elvira Josel Castro. Appearing as counsel for respondents in intervention, for intervenors, Ana Teresa Risa Contiveros et al., Attorney Juan Alfonso Torrevillas. For intervenors, Cabral et al. And Senator Pilar Juliano S. Cayetano, Attorney Herminio Harry Roque, and Attorney Ethel Avisado. For intervenors, De Venecia et al., no appearance. I'm sorry. For intervenors, Catholics for Reproductive Health, IPPRP, Mones, and Mapandi, Attorney Clara Rita Padilla. That's all.
We'd also like to acknowledge the appearance of Senator Pia Cayetano. Okay. Counsel for respondents may kindly take their seats. Counsel for petitioners, you're ready to resume the arguments. And as stated in the advisory, it is now Attorney Luisito Liban's time. Clerk of Court, how many minutes are we going to give Attorney Liban?
Attorney Liban shall argue for 20 minutes, and Attorney Gil Gana shall argue for 5 minutes.
Attorney Liban may please approach the podium and begin the presentation. Kindly identify for us the issues that you are going to address. Kindly identify for us the issues that you are going to address.
I will discuss, Your Honor's issue of religious freedom, equal protection, free speech, and other related issues, Your Honors. Madam Chief Justice, and may it please this honorable court, allow me to begin with a statement of fact. RA 10354, or the RH law, contains 30 sections. Of these, 24 sections directly or indirectly deal with the promotion, distribution, and funding of artificial contraceptives. In short, 80% of the law is about contraception. Contraception prevents pregnancy. When used on a massive scale, it inhibits population growth. This is what the RH law seeks to achieve. To attain this objective, government will fund, promote, and distribute contraceptive drugs and devices. Verse It will force people to participate in the state-sponsored propagation of contraceptive drugs, despite such act being forbidden by their religious beliefs. The Catholic Church teaches that artificial contraception is intrinsically evil and immoral because it removes the procreated element from the conjugal act. In Section 23, subsection A3 of the RH law, for instance, the law compels a conscientious objector to refer a person seeking reproductive health services to another healthcare provider. The same duty to refer is found in Section 7, where the healthcare facility owned and operated by a religious group is also forced to refer the person to another healthcare facility. At first glance, Sections 7 and 23A3 of the RH law appear to respect religious freedom by excusing a conscientious objector from liability for refusing to extend reproductive health services. But what it gives with its right hand, it takes back with its left by forcing the objector to immediately refer the person to another healthcare provider. By referring the person to another healthcare provider, the Catholic objector immediately commits a grave offense under the teachings of the Catholic Church. The Catechism of the Catholic Church states that a Catholic who deliberately leads another to commit a serious sin himself commits a grave offense. It is the act of referring which is the equivalent of leading another to commit a serious sin, which is the sin itself. It does not matter, therefore, if the person seeking reproductive health services eventually gets the services. And if the person seeking reproductive health services did get such services from the other healthcare provider, the Catholic objector who had referred him becomes responsible for the sin of that person and the other healthcare provider. Catholic teachings make a Catholic responsible for the sin of another if the Catholic culpably cooperates with the latter in the commission of sin. What the rule on compelled referral does is this. It forces a Catholic to choose either of two things. One, obey his religious beliefs and face the consequence of imprisonment or fine. Or two, disobey his religious beliefs in order to avoid criminal sanctions. The burden imposed is so great and direct that it violates his constitutional right to religion. Your Honors, even free speech is sacrificed for the aim of forcibly promoting and flooding the country with potentially harmful drugs and devices. Section 23, subsection A1 of the law punishes with imprisonment or fine any healthcare provider who shall, quote, knowingly withhold information regarding programs and services on reproductive health. In effect, this provision forces the healthcare provider to speak up about reproductive health, even if his conscience bids him not to. The Bill of Rights, which guarantees to the individual the liberty to utter what is in his mind, also guarantees him the liberty not to utter what is not in his mind. To a Catholic healthcare provider, the burden imposed by Section 23A1 is heavier. Aside from interdicting free speech, it also restrains his free exercise of religious freedom. His religious beliefs forbid him from promoting artificial contraception because it is intrinsically evil and immoral. Yet, Section 23A1 compels him to do so under pain of penalty. Again, it is a choice between following his faith despite the threat of criminal sanctions and succumbing to the fear of imprisonment by forsaking his religious beliefs. Another part of Section 23A1 threatens a healthcare provider with criminal prosecution for intentionally providing incorrect information regarding programs and services on reproductive health. Since the RH law does not define what incorrect information means, any healthcare provider may be inhibited from speaking up for fear that his message might be interpreted as being incorrect. The threat of prosecution creates a chilling effect, deterring him from uttering what is in his mind. Therefore, Section 23A1 amounts to a prior restraint on free speech. Section 14 will make sex education mandatory in public schools and optional in private schools. The classification violates equal protection. It discriminates against parents of children in public schools who are forced to accept sex education for their children. Of course, parents who do not like sex education may transfer their children to private schools that have no sex education. But what if they cannot afford to do so? Sadly, their only option is not to send their children to school at all. Parents of children in public schools are also preempted from exercising their primary and natural right to rear and educate their children, contrary to Article 2, Section 12 of the Constitution. By forcing them to accept sex education, government has supplanted this primary right vested in them by the Constitution. This is clearly a grave abuse of discretion on the part of Congress, because instead of simply lending support to this basic parental right as required by the Constitution, the state actually usurps it. The mandatory sex education in public schools also curtails the right of parents to found a family in accordance with their religious convictions, which the state is obliged to defend under Article 15, Section 3 of the Constitution. For Catholics, Section 14 offends the church teaching directing parents to be the first educators of their children and to be their first heralds on matters of faith. The discrimination extends to children in public schools, forced to carry a heavier load because of the addition of topics on reproductive health. They are compelled to spend longer study hours and will have a tougher time moving up to the next academic level compared to students without sex education. In fact, even parents and children in private schools are potential victims of discrimination under Section 14. Since sex education is optional in private schools, some schools may adopt it and some may not. The result is unequal application of sex education among people of the same class. To illustrate, those in private schools that adopted sex education are placed in the same position as those in public schools. Their rights to equal protection and religion, among others, are violated. Parents in private schools that rejected sex education are also discriminated because they are deprived of the choice to allow the school to teach their children sex education. They say that the RH law aims to reduce maternal mortality ratio of 160 maternal deaths for every 100,000 live births. Well and good. But is this enough reason to violate sacred constitutional rights? Does it justify exposing around 25 million of women of reproductive age to the possibility of harm caused by artificial contraception? And why push for the massive distribution and use of artificial contraceptives when there are natural methods of avoiding pregnancy? These natural family planning methods are safe because they involve no chemicals, are at least 97% effective, and are practically free. No less than the medical experts consulted by Congress had admitted that contraceptive drugs and devices have adverse effects. The product labels of these drugs and devices warn users of increased risk for various types of serious ailments like breast cancer, venous thromboembolism, pulmonary embolism, heart attacks, and strokes, among others. The UN International Agency for Research on Cancer, through a working group composed of 21 scientists from 8 countries, has classified combined estrogen-progestogen oral contraceptives as Group 1 carcinogen, the highest level of cancer risk. In 1996, an international collaborative analysis of some 54 medical studies based on over 53,000 women with breast cancer showed that use of the pill starting in adolescence increased risk of breast cancer by 60%. In fact, more than 16,000 mass tort cases have been filed against the manufacturers of hormonal contraceptives in the US, alleging an increased risk of blood clots, pulmonary embolism, gallbladder diseases, some even resulting in deaths. Article 2, Section 15 of the Constitution mandates the state to protect the right to health of the people. Moreover, Article 16, Section 9 commands the state to protect consumers from hazardous products. Webster defines the verb to protect to mean, quote, to cover or shield from exposure, injury, damage, or destruction, close quote. As these contraceptives have the potential to cause harm, the duty to protect demands that the state, at the very least, adopt a hands-off policy. Unfortunately, this is not the case. Instead of steering clear from contraceptives, government will do the exact opposite by funding, buying, and flooding the country with these potentially harmful drugs. It will require its entire machinery, including the LGUs, to aggressively promote, distribute, and make available for free these drugs to our women, especially the poor. It is indeed puzzling why Congress will spend billions of pesos of limited resources, mobilize the entire machinery of the LGUs, threaten people with criminal sanctions, and violate fundamental rights over this piece of legislation. Maternal deaths cannot be an excuse. As stated, there are around 160 maternal deaths for every 100,000 live births as of 2008, or a mere 0.016%. While this number is unfortunate, the problem of maternal deaths pales in comparison with the number of deaths associated with serious illnesses. For example, 100,908 people die of heart diseases in 2009 alone. Vascular diseases account for 15,670 deaths. Malignant neoplasm, pneumonia, tuberculosis, chronic respiratory diseases, and diabetes were responsible for 174,743 deaths. These numbers clearly dwarf the number of maternal deaths, yet no law of the same magnitude as the RH law has been passed specifically to address these serious illnesses. Is Congress not discriminating against the victims and potential victims of these serious illnesses? Many of them are poor. Are they not entitled to the equal protection of the law? Your Honors, the RH law is a piece of legislation that has gone berserk. It violates multiple fundamental rights, unfairly targets the poor, misuses our limited resources, and exposes 25 million of fertile women to health risks. As an aggressive population control law, it also trumps the right of future generations to be conceived. For these reasons, we respectfully ask this Honorable Court to declare RA 10354 unconstitutional. Thank you, Your Honors.
Thank you, Attorney Liban. Justice Mendoza.
Yeah, I defer to Justice Abad. I will
Justice Abad.
Justice Abad. I will
Okay,
ask
Justice
questions,
Abad.
please.
Counsel, you said that the RH law constitutes, or the contraception constitutes about 80% of the RH law. And you related to the right to life and the right to health of women. Is that correct?
That's correct, Your Honor.
I want to be clarified. This relates to the constitutional right to life and the right to health that happens to be important to the Catholic tenets, as far as I know. No?
That's
the
correct.
right to life, that's why you have their pro-life.
Yes, Your Honor.
And the right to health, because the body is the temple of the Holy Spirit, according to the Catholic tenets. Now, my understanding is that there are three ways of preventing the birth of a human being. The first is by preventing the woman's ovary from ovulating or producing ova or eggs. Is that right?
That's correct, Your Honor.
The second is by preventing the sperm from fertilizing the ovum. Is that
That's
right?
correct, yes.
And the third is by abortion after the ovum has been fertilized. Correct?
That's correct,
No.
Your Honor.
Of these three, actually that was discussed only at the last hearing, it is abortion that the Constitution prohibits. Is that right?
Yes, Your Honor.
There is abortion when the ovum is prevented from being implanted in the womb. Correct?
That's correct, Your Honor.
There is also abortion when after implantation in the womb, it is prevented from developing into a fetus.
Yes, Your Honor.
Or if a fetus develops, abortion kills it before it is delivered alive by its mother. Correct?
Yes, Your Honor.
Does the Constitution prohibit abortion? I
Yes,
think
Your
that
Honor.
was one where we lingered. It does, it prohibits. The RH law does not, on its face, support abortion. Is that correct? On its face.
On his face, yes.
In fact, it prohibits the government from sponsoring the use of abortive patients that cause abortion. Right?
That's correct, Your Honor. On its face.
We say that the second and third ways of preventing birth is by preventing ovulation, and if this is not achieved, by avoiding fertilization of the ovum. These are made possible through the use of contraceptives. Is that correct?
That's correct, Your Honor.
Now, contraceptives can be in form of birth control pills that women can take at prescribed times and dosages. Is that right?
Yes, to prevent...
Or injectables with effects that last for about 2 months, from what I read from some literature.
Yes, Your Honor.
Or birth control patches that last 7 days, from what I read also. Do you
Even
agree with
longer,
that?
Your Honor.
Or barriers like condoms, diaphragms, and contraceptive sponges that prevent the meeting of the sperm and the ovum.
Yes, Your Honor.
Correct? No. Or intrauterine devices planted in the womb that last 5 to 10 years. They ensnare and kill foreign organisms like the sperm foreign to the woman.
That's
You agree?
correct. Yes, Your Honor.
These contraceptives either prevent ovulation or avoid fertilization of the ovum. Yes?
Yes, Your Honor.
With contraceptives, a man and a woman can have sex and not have a baby. Right?
That's the idea, Your Honor.
This is not abortion.
Before the fertilization?
Yes, this is
Yes,
not
that's
abortion.
correct.
So we can say that avoiding ovulation and fertilization by themselves are not prohibited by the Constitution. Is that correct?
That's
By
correct, Your
themselves.
Honor. That's correct, Your Honor.
Now, but apart from guaranteeing the right to life of the unborn child, the Constitution also guarantees the right to life of the mother. It says in Section 12, Article 2, the state shall equally protect the life of the mother and the life of the unborn from conception. You're aware of that?
I'm aware of that, Your Honor.
Some says that this is the justification for therapeutic abortion, where pregnancy threatens the mother's life, and abortion has to be done to save her. No, but that's not the point. At any rate, it says, equally protect the life of the mother and the life of the unborn child. I will read it again. The state shall equally protect the life of the mother and the life of the unborn. It does not say the life of the woman and the life of the unborn. Rather, it says the life of the mother and the life of the unborn. Correct?
That's correct, Your Honor.
So the right to life of the unborn child and the right to life of the mother are connected rights.
Yes, Your
You
Honor.
agree? In effect, the Constitution guarantees the right of the unborn to be a child of her mother and the right of the woman to be a mother or have a child. Correct?
I agree, Your Honor.
Now, but there is another constitutional right that women enjoy in common with men. The right to health. Do you know that?
Yes,
think you
I do,
mentioned
Your
that.
Honor.
Let me read to you section 15 of Article 2. It says, the state shall protect and promote the right to health of the people. This is not just about the right of women to health, but more about the duty of the state to protect and promote her health. You understand that?
Yes, Your Honor.
As Webster defines the term, health means physical and mental well-being, freedom from disease, from pain or defect. Health means normalcy of physical functions. So this is what the government or the state has a duty to promote and protect. Is that right?
That's correct, Your Honor.
Women, like men, have the right to health. Correct?
Correct.
Now, I notice that the RH law favors use by women of the full range of modern family planning methods, right?
Yes, Your Honor.
The strategy, from my sense, is to use the full powers of government to make this possible, correct?
Correct, Your Honor.
So Section 9 of the RH law declares, without qualms or reservation, that hormonal contraceptives, intrauterine devices, and injectables are safe for women's use. It declares it to be safe by law. You agree with that?
Yeah, from the language, Your Honor, that's correct.
Indeed. And that they are non-abortive patient. That's also what the law says. These contraceptives are non-abortive patient. Correct?
Yes, Your Honor.
Indeed, Section 9 directs the inclusion of this range of contraceptives in the National Drug Formulary. Is that right?
That's correct, Your Honor.
Now, paragraph 7 of Section 3 of the Generics Act of 1988 states that the National Drug Formulary also constitutes the country's essential drug list.
Yes,
No?
Your Honor.
That means that these contraceptives that the law declares as safe go into the essential drug list of the country, correct?
Correct, Your Honor.
The RH law compels all public health facilities to provide a full range of modern medical family planning. It also compels private health facilities, with certain exceptions, to provide the same services to paying patients. You agree?
That's what the law says.
Those who are exempt must, according to you, endorse people seeking these services to those who are willing to provide them.
That's right.
I'm not willing to to prevent your ovary from producing ovum. You go to him because he will do it for you. That's the way how it looks, isn't it?
It looks to be that way, Your Honor.
Now, all in all, the RH law decrees a massive use of contraceptives that prevent ovulation and fertilization in women to control birth as part of its family planning program, right?
Right, Your Honor.
Now, the bottom line question, it seems to me, is whether or not in adopting the core strategy of minimizing birth by interfering with the normal functions of women's reproductive organs, the RH law fulfills its constitutional duty to to adequately protect their right to life and to health. Do you agree with that?
I think the law violates that particular constitutional provision or mandate to protect the health of the people. That's correct, Your Honor.
Well, so the issue is whether this law, does this law contain enough protection to women that to promote and protect their right to life and their right to health? That's the question, I think. You agree with that?
If you're asking, Your Honor, if the law provides for mechanisms to...
No. The issue, whether this is the central issue in this case. Do you agree that the central issue in this case is whether or not, in adopting this strategy of minimizing birth by interfering with the normal functions of women's reproductive organs, the RH law fulfills its constitutional duty. It contains provisions that adequately protect their right to life and to health?
No, I don't think so, Your Honor. I think the law, one, does not provide for safety mechanisms. Number two, and the more important core point is that it is not the business of the state to be the primary mover, initiator, funder, promoter, and distributor of these potentially harmful drugs and devices, because that violates Section 15.
Does the law provide protection against those practices?
I don't see anything of that sort, Your Honor.
Yeah, that's what I'm saying. That is the issue. Partly the issue, from my point of view, is that this law does not protect the right, as the duty of the state, protect the right of women to life and to health. You agree?
Yeah, I agree, Your Honor.
Now, who has the burden of proving that the RH law adequately protect the women's right to life and to health?
I think
Would
it
you
should
care
be.
to venture?
My view, Your Honor, is that since the constitutional duty to protect the health of the people is directed to the state must have that obligation and burden.
Right, it must show that it has complied with the duty. I have not found in my research any provision of the Constitution of other countries that forbids abortion. As a matter of fact, I don't think there is any single country in the world where the Constitution forbids abortion. I don't know. If you can find one, you let me know. But I've tried to find, but there's none. So it's unique to us, you know. It's unique to us that our Constitution forbids abortion. That's how important we consider it now. And also, it guarantees women's right to live, have a child, and be healthy. There's none in other constitutions like this. Okay. This is uniquely Filipino, a part of our deep values, and enshrined by covenant of the people in their constitution. Do you agree?
I agree, Your Honor.
In contrast, the Constitution adopts 6 basic principles and 22 state policies in Article 2. Yet nowhere does it regard as one of its basic principle or state policies the adoption of family planning or birth control. That is not in the Constitution.
Yes, Your Honor. In fact, if memory serves,
consequently, in pursuing birth control, the government bears the heavy burden of showing that its strategy of interfering with the normal functions of women's reproductive organs adequately protects their rights to life and to health. Do you agree?
yes, I agree, Your Honor.
Government supplied contraceptives should not permanently impair the right of women to have children. Even if they use it, it should not permanently impair the right to have children. Correct?
Correct, Your Honor.
The women's ovaries should be able to recover fully from whatever chemical mambo-jumbo they are subjected to. Correct?
Correct, Your Honor.
Further, the use of contraceptives should not result in the birth of children with physical or mental deformities. The state's duty is to guard against all of this. Correct?
Correct, Your Honor.
Now, for the right to life of the child includes the right to a normal, healthy life, not as what they call it, as an imbecile or one with no arm or no eyes or things like that. No? Right. Now, Is the Supreme Court, by the way, a trier of facts? Because that is an issue that we have to
No, Your Honor.
deal with. But it's not, no? But can the Supreme Court, in cases before it, take judicial notice of facts that are self-evident?
Yes, Your Honor. If there is universal notoriety, Your Honor, the law allows you to take
Section
judicial
2
notice.
of Rule 129 of the Rules of Evidence provides that a court may take judicial notice of matters which are capable of unquestionable demonstration or self-evidence. Have you heard of this rule?
Yes, I have, Your Honor.
Now, take the case of hormonal contraceptives. Admittedly, they are not human hormones. No? They are synthetic hormones, mixture of chemical compounds that are ingested in the woman's body, correct?
Correct, Your Honor.
One group of manufacturers claim that their hormonal contraceptives can prevent women's ovum from producing ova or egg cells. Are you aware of this?
I'm aware of that, Your Honor.
With these contraceptives, if the sperm arrives at the woman's ovary, it will find no ova or eggs, preventing fertilization that normally would generate human life. Correct?
Correct, Your Honor.
Now, another group of manufacturers claim that their hormonal contraceptives induce the release of thick mucus that will prevent the sperm from penetrating the ovary. Are you aware of that?
I'm aware of that, Your Honor.
Right. Would you say that the court needs medical expertise to determine that hormonal contraceptives in fact disrupt normal functions of the woman's ovary? Take this reasoning. Can the court, by logic and common sense, make such determination? As we said, the makers of these contraceptives themselves claim that their products can stop healthy ovaries from producing ova or eggs, or can induce them to produce thick mucus that will stop sperm penetration, correct?
Correct, Your Honor.
With these claims, manufacturers actually admit that their contraceptives disrupt the normal functioning of women's healthy ovaries, correct?
Correct, Your Honor.
I have healthy eyes. If they will use chemical to make my eyes unhealthy, I will not be able to see. No? So the chemical will be interfering with the normal function of my eyes, correct?
Correct, Your Honor.
Okay. When they take no contraceptives, women's ovaries produce eggs. No contraceptives. Women's ovaries produce eggs that sperm can fertilize, right?
Right, Your Honor.
But when they take certain contraceptives, women's ovaries cease to produce eggs. That's what they claim, right?
Right, Your Honor.
The ovaries become dysfunctional, correct?
Correct, Your Honor.
Subjected to other contraceptives, ovaries release thick mucus that are normally not there, blocking sperm penetration, right?
Right, Your Honor.
So admittedly, contraceptives attack healthy ovaries to make them dysfunctional and reject fertilization. The court need only common sense, not medical expertise, to see this truth based on the claims of the manufacturers themselves. Now, to protect women's right to life and to health, the government, as you said, favored contraceptives. Is that true, correct?
That's true, Your
Now,
Honor.
well, but to protect women's right, it is necessary that those contraceptives should be safe. Because if they are unsafe, they cannot protect the lives and the rights of women, correct?
That's correct, Your Honor.
So contraceptives have to be safe. Okay. Unsafe contraceptives will violate the right of women to life and to health, correct?
Unsafe, you mean, Your Honor?
Yes. The term safe, according to Webster, means free from damage, danger, or injury. So hormonal contraceptives may be considered safe if they pose no damage or danger or injury to women who use them. Is that right?
Yes, Your Honor.
Can the court determine by unquestionable demonstration, needing no trial, that hormonal contraceptives are safe or not safe? What do you think?
That might be a question of fact, Your Honor, but insofar as the risk, the presence of health risk is concerned, I think that is something within which this
Well,
honorable can take seriously.
my suggestion is simpler. All one needs to do is buy such contraceptives from the drugstore and read from the insert the best things that manufacturers can say about their products. I will read from the insert of one of the most popular oral contraceptive in the Philippines, the Trust Pill. Trust, ibig magtiwala ka, ibig sabihin, Trust Pill. Manufactured, that bears the generic name ethinyl estradiol, levonorgestrel. You remember this word, the levonorgestrel, because this is a subject of a later point that I'm going to make, and ferrous fumarate. This drug is manufactured in Thailand, of all places, by Pans Chemical. I don't know if it's related to the Pans that makes the cream. Imported by DKT Philippines of Libis, Quezon City. I will just read the pertinent portions because the insert is quite long. It says, prior to starting this Trust Pill, pregnancy must be ruled out. However, should pregnancy occur while taking the tablet, uminom ka na nito for a number of days, and pregnancy occur, it says, the administration has to be withdrawn at once. That's what the manufacturer says. Stop using it. So what does this imply? No other but that unless taking of this pill is stopped, the pill will harm the child in the womb. Huh? The pill will harm the child in the womb. This tells us that this pill, a hormonal pill, declared as safe and non-abortive patient by the law, is after all a double-barrel pill. It pursues the ovum to prevent ovulation and then shoots the zygote or little junior if fertilization takes place. Abortion, is that right?
That's right.
But the woman taking the pill cannot know. I ask all the women here, cannot know that she has become pregnant unless she sees or feels the signs of pregnancy. Unfortunately, from what I read, these pills mask such signs. And women using the pill, if you're a pill user, you're assured by it, by this pill, let me see, I have the box here. This one.
I also have this.
You are assured by it that the pill will prevent pregnancy. So there's no basis for you to take pregnancy test on a daily basis to find out if you are pregnant. The woman has a right to keep the child. No, in case of pregnancy, despite taking this, the woman has the right to keep the child if it is there. Correct?
Correct, Your Honor.
And the child has the right to live. Correct?
Of course, Your Honor.
But the RH law, which is a duty to protect the life and the health of the mother and the child, has not devised any specific protection to the right of the mother and the child in this particular situation. Correct?
Correct, Your Honor.
Now, the insert further reads that this pill is contraindicated for use, contraindicated, makakasama, in women with liver disorders, clotting disorders, breast and cervical cancer, sickle cell anemia. The drug itself says this, hormone-active tumors, hyperlipidemia, I don't know what that is, severe cardiovascular diseases, strokes, heart attack, previous or existing thromboembolic disease, and idiopathic jaundice. To be honest, I've never read a drug insert that presents as many risks to health as this has. So it would appear that these government-sponsored contraceptives mentioned in the law are based on the claims of their manufacturer, not altogether safe. You agree with me?
Yes, Your Honor. And if I may add, the effect of the RH law, considering the risk that you mentioned, is actually to institutionalize those risks because it is being sponsored no less than by government.
Okay. The strategy of the family planning program under the RH law is to reach the poor and marginalized, who are the ones facing housing, food, medical, and educational problems. You agree?
I agree, Your Honor.
Actually, the target of this is not those with money, because those with money can send their children to school and give them good education and feed them well and give them housing and everything that they need. So the target here is the poor. To reduce the size of the poor. To make lesser poor people in this country. You agree with that?
I agree, Your Honor.
Now, will the women in the slums have the chance of getting medical tests and examinations to determine if they have the health disorders in this list? The woman in the slum, would he have the capability, the chance to determine he suffers from these things, to avoid taking them? Do you think so?
No, I don't think so, Your Honor.
Well, they have no money to buy food. So how can they get this test? So, does the RH law require compulsory testing of proposed users to prevent fatal results if these contraindications are present?
No, Your Honor.
It does not. Bayer Company is reported to have set aside more than $1 billion to settle valid claims that their hormone drugs approved by the FDA has caused illness to a broad number of users. Bayer already admits that has produced contraceptives approved by FDA. So you cannot say the court has to rely on the approval of FDA to say they're dangerous. It's not as easy as that. And by the US FDA. Okay. Does the RH law provide for remedy of recovery of damages against contraceptive manufacturers like this one in Thailand, which is not under the jurisdiction of our FDA and its small distributor in the Philippines? Does the law has protection against that?
No protection, Your Honor.
Bayer, you can sue Bayer, but
May I say something
further,
about
the insert says, take 1 tablet a day without interruption for 28 days, or as directed by a healthcare provider. Healthcare provider. But down the line, it says, consult a healthcare provider for a medical and gynecological examination before starting. You think the poor in the slum has this chance to get a medical and gynecological examination before starting?
No, Your Honor.
This bill requires prior to use medical and gynecological examination, obviously by competent physicians specializing in the matter, not the healthcare provider in the center, in the health center. Okay. Unlike most sensitive medicines we are using, medical pack containing this pill, this one, does not carry the restriction that it needs to be prescribed by competent physician. None. I've gone through it. There's nothing that says that it should be prescribed by a competent physician. Although sabi niya sa kanyang literature, they should be examined by the physician before use. They should undergo several tests before use. But it does not say that it can be prescribed only by physician. Does the RH law provide for restricted use of contraceptives with abundant contraindications?
No, Your Honor.
It does not. The insert also tells the user to take 1 tablet a day without interruption for 28 days, or as directed by a healthcare giver. This means, does it not, that the healthcare provider, not necessarily a physician, can change the timing and the dosage following the instruction here?
Yes, Your Honor.
Does the RH law prohibit non-physicians from advising users about correct dosage?
No, Your Honor.
Does not. As a matter of fact, it says to train them. I don't know how you can train them, barangay healthcare, to train them to do a lot of these things, gynecological examination. Would not this law be constitutionally void for what it does not provide, considering the state's duty to protect and promote the right of women to health?
Yes, I agree, Your Honor.
Health, as Webster defines the term, means physical and mental well-being, freedom from disease, pain, or defect. Health means normalcy of physical conditions. So women have the right to be free from government-sponsored sickness. Do you agree?
I'm sorry again?
Women have the right to be free from government-sponsored sickness,
Yes, Your Honor.
free from government-sponsored pain,
Of course, Your Honor.
free from government-sponsored defect.
Yes, Your Honor.
Women have the right to have normally functioning vital organs, correct?
Yes, Your Honor.
They have the right to walk in the park or in the malls in good health,
Yes, Your Honor.
free of worries over contraceptives that the government had assured them are safe,
Yes, Your Honor.
correct?
Yes, Your Honor.
Does the RH law comfort us that those reigns of modern birth control are nothing to fear about?
Not by their word. We shouldn't rely, Your Honor.
Can the government sponsor a family planning program that does not ensure the protection and promotion of women's right to health?
No, I don't think so, Your Honor.
Section 46 of Rule 130 of the Rules of Evidence, ito, the court cannot look, but Section 46 of Rule 130 of the Rules of Evidence states that a published treatise, periodical or pamphlet on a subject of science is admissible as tending to prove the truth of the matter stated in it if the court would take judicial notice of the expertise of the author or authors.
Yes,
You
Your
are aware of that?
Yes,
Actually,
I'm
the
aware.
court has been, that's a practice in this court, to refer to journals that are widely accepted as by the profession where it belongs. Now, in medicine, these would be medical journals or reports of the highest reputation in the medical profession, correct?
Correct, Your Honor.
Let me just read a few excerpts from these medical journals or reports. From the International Union Against Cancer, after adjusting, it says, after adjusting for education level, body mass index, age, etc., breast cancer risk significantly elevated in use of oral contraceptives before 25 years old and before 1971. That's an early study. Right. Now, from the Journal of American Heart Association, a recent report, 2009, third generation oral contraceptives, this is modern, bago na, containing desogestrel or gestodine, confer the same risk of first ischemic stroke as second generation oral contraceptives, containing what I told you to remember, levonorgestrel, which these pills contain. From Mayo Clinic, 2006 study, The use of oral contraceptives is associated with the risk of premenopausal breast cancer, especially with use before FFTF in Paru's women. And from the World Health Organization itself, its International Agency for Research on Cancer 2005 studies. Previously, it says, combined oral contraceptives have been determined to be carcinogenic to humans, but only primary liver cancer was specifically implicated. But the working group concluded that combined oral contraceptives alter the risk of several common cancers in women. They increase a woman's risk of cervical cancer, breast cancer, and liver cancer. Now, the RH law declares hormonal contraceptives as safe in view of medical evidence that they are not. Does this declaration serve to protect and promote women's right to life and to health?
No, Your Honor.
Poison, according to Webster, is a substance causing illness when eaten, drunk, or absorbed, even in small quantities. And illness is the opposite of health, correct?
That's correct, Your Honor.
Hormonal contraceptives, as we have seen, are essentially poison, since they cause illness or death, or makes women not healthy, normal, or well. Can Congress pass a law that sponsors the use of poison to prevent childbirth?
Of course not, Your Honor.
But it does. The law describes these things as safe. In other words, the law has arbitrarily and falsely declared hormone contraceptives, intrauterine devices, and injectables to be safe. Correct?
Yes, under Section 9.
Thank you very much.
Thank you, Your Honor.
Justice Mendoza.
We'll cover what you spoke about. You mentioned about a referral that it is an
Can
infringement.
a microphone please be given to Justice Mendoza?
It is an infringement of the one's free exercise of religion. What situation are you referring to? Suppose a mother is in an emergency situation, life-threatening. Is that situation covered by what you mentioned?
No, Your Honor, because the obligation to refer refers to a situation where there is no emergency. Because if there is an emergency, the last clause of the provisions will apply, meaning the conscientious objector must save the life of that patient. So the forced referral clause that we are objecting on grounds of violation of freedom of religion does not contemplate an emergency.
So you are referring to the use of contraceptives approved by FDA.
Yes, Your Honor, or it could be a request for information, Your Honor.
And request for information. If he does not disseminate information on that, he will be penalized.
He can be penalized, Your Honor, under another provision, 23A1.
And you are objecting on that.
Yes, it violates free speech, Your Honor.
Your point is that what he cannot do directly, he is doing. He is forced to do indirectly. Is that your point?
On the matter of duty to refer, that's correct, Your Honor.
Now, with respect to this, the free exercise of religion, is this absolute?
It's there's no such thing as absolute right, but it occupies the highest position, being described as inalienable and the most sacred of all human rights in Escritor as well as Ebral Nilag.
In the comments, they said the RH law is an exception because of the compelling interest test. It passes the compelling interest test. Do you agree on this position?
No, Your Honor, there is no compelling interest involved here, particularly with regard to the questionable provisions. As I said, for instance, with regard to Section 7 and 23 relating to the duty to refer, there is no compelling state interest that will override or trump religious freedom. It's a choice between, on the part of the person seeking reproductive health, he is requesting for information and probably some contraceptive devices like condoms or pills. On the other hand, you have a situation wherein the conscientious objector is being compelled to violate his own religious beliefs. There are remedies and options available to the person seeking reproductive health, but not quite with regard to the conscientious objector, because for him the choice is very dire and direct. Either he violates his own teachings to avoid criminal prosecution, or maintains his religious beliefs despite the criminal sanctions. So in terms of gravity, I think the right of the conscientious objector to religious freedom far outweighs the right of a person for information or request for reproductive device.
How about overpopulation? Do you not consider it a compelling interest of the state?
Your Honor, overpopulation is a very relative term. In terms of persons or population within a kilometer, which we call population density, Philippines only has 374 people within a square kilometer, compared to Japan, Singapore, which have something like more than 1,000 per square kilometer. And yet these people, these countries, are prosperous and economically good. So it's not the problem of population control that actually is the problem, but the problem of governance, I think, at the end of the day. So, and also, may I add, population is not necessarily bad. Just last year, HSBC predicted that the Philippines could become the 16th largest economy in the world by 2050. And one of the major reasons is the population of the Philippines, its young workforce, as compared to the dying economies as described in that research. Economies like the economies in Europe, France, Italy, and even Japan, Singapore, they're all aging and dying. In fact, the former Prime Minister of Singapore publicly twice regretted having adopted a reproductive health system, because now Singapore, Japan, Korea, and even Canada and Russia have now fallen below the replacement rate of 2.1. And therefore, at some point in time, they will begin to age, as in fact Japan, Singapore are aging, and then they will become less competitive because there will be not enough workers to man the shops and to run the economy. And also, just very recently, Your Honor, the papers were screaming with the bankruptcy of Detroit, no less than Detroit. And according to news reports, one of the reasons for its bankruptcy is its declining population. There are more old people than there are young, and therefore the economy can no longer tolerate or manage with such a very small workforce, Your Honor.
So, do you know the total fertility rate of the Philippines right now?
Total fertility rate of,
The Philippines right now.
I think it's 3.6, thereabout.
3.6. And the replacement rate is what?
2.1.
2.1. So we are over that rate.
Yes, but we are falling very fast, Your Honor, even without reproductive health. It has fallen from 7, Your Honor, sometime in the 70s, down to 3, Your Honor. So even without reproductive health, according to economists and demographers, we will actually reach the point close to the replacement rate, even without reproductive health law, Your Honor. And with reproductive health law, that will only facilitate our falling below the replacement rate of 2.1.
it is just a prediction. What was the basis of the prediction of that study?
HSBC.
HSBC.
The basis, Your Honor, is that if you go back in history, the great economies of the old, Britain, France, Italy, they were all driven by human capital. The Industrial Revolution was driven by human capital. And a Nobel Prize winner in economics, Gary Becker, wrote many books emphasizing the importance of human capital because it is human capital that will run the economy of any nation. And I think one of the sought-after geopolitic strategies, Stratfor, also mentioned population as a key factor and even predicting that by the middle of the century, the great empires of old will cease to exist because of their aging population.
What is your objection? Can you expound on it, on your reason for objecting to the age and development appropriate information in schools, otherwise sex education in public schools?
You're referring to sex education, Your Honor?
Yes, that's...
We object to sex education on multiple grounds. First, it violates equal protection because in the law, sex education is mandatory in public schools but optional in private schools. With regard to parents in public schools, they are left without any choice but to live with sex education for their children, unlike parents in private schools. So I think there is discrimination against the parents of children in public school. Number two, the mandatory sex education in public schools will also violate their natural and primary right under the Constitution to rear and educate their children for civic duty and for the development of moral character. It will also violate the right of the parents to found their family in accordance with their religious beliefs. So, in addition to discriminating against the parents of public school, even the children in public schools will be discriminated because they will have to bear a heavier burden because of the additional topics on reproductive health that will be imposed upon them, unlike their counterparts in private schools without sex education. In fact, the violation of equal protection is so obvious that even parents and children in private schools are exposed to a possible unequal protection. Why? Because the law says private schools have the option. So some private schools may adopt it, some may not. You have a situation wherein people within the same group will be treated differently. And if a particular private school opts for sex education, parents in that school who may feel that sex education is not for the children will again be confronted with a potential violation of their religious freedom, the right to rear and educate their children, and also the right not to be exposed or not to expose their children to sex education. In fact, the multiple discriminations also affect even parents of private schools who opt for or who did not opt for sex education. Because there are parents probably who would want their children to be taught sex education. But if the school where the children go to opt not to adopt sex education, then that parent will be forced to do the sex education by herself. And again, in relation to the other parents whose schools opted for sex education, they are discriminated against, Your Honor.
You are assuming that the public schools, the authorities are responsible.
I cannot assume that, Your Honor. I'm sorry.
Now, regarding a conscientious objector, you mentioned earlier that abortion is not allowed under the Constitution.
That's correct.
And that so You have no objection on procedures before fertilization.
As a matter of law, yes, Your Honor. It's not covered by the law.
So, if, for example, a male or female seeks the services of a doctor for vasectomy or tubal ligation, and it is not, he's not, they are not seeking abortion, but only prevention of fertilization. Can a medical or a doctor or a nurse, can he invoke his right to object
If he's a
based on
Catholic,
his conscience?
if it is a Catholic, Your Honor, because the Catechism of the Catholic Church also considers it intrinsically evil and immoral, sterilization.
But only with respect to Catholics.
Yes, I cannot speak for the other faiths, Your Honor.
But under the Constitution, that is allowed.
Which one, Your Honor?
The operation, the vasectomy or tubal ligation.
I don't know of any law against it, Your Honor, if that's what you mean.
That's all, Chief.
Specifically, which petition you filed?
Particularly Couples for Christ, but I represent the other petitioners as well, Your Honor.
That's why you spoke about life, protect the right to life, although the petition of the Couples for Christ does not involve the right to life, right?
I don't think it covers the right to life, Your Honor, but the other petitioners actually raised that as a major point.
Yes. And you are joining them.
Yes, Your Honor.
I was looking at your petition, Counsel, and I noted that you filed a petition for certiorari and prohibition. Under what rule has this been filed?
65 prohibition, Your Honor, although certiorari was included, but the main point is prohibition, Lord, because we would like to stop public officials performing ministerial functions, Lord, Your Honor, from implementing the law.
And precisely, it's what is the object of a petition for certiorari?
To stop a particular body, tribunal, officer performing judicial or quasi-judicial.
Quasi-judicial.
That's correct. Yeah.
Okay. And here, has the government been performing judicial or quasi-judicial function?
No, Your Honor. That's why we also included prohibition, Your Honor.
Prohibition.
That's correct.
And in fact, Counsel, are you aware that in many, many cases that pass through this court, the medium of certiorari has been used, even if there is no ruling by a judicial or quasi-judicial body. Are you aware of that?
I think so, Your Honor. Yeah.
And for example, in our recent case about the party list law, which we deliberated upon in Baguio, the medium was also certiorari and prohibition. Are you aware that in that case, the ruling of the court was there was even no grave abuse of discretion? So, can you, in your memorandum, can you point out the cases where the court disregarded the medium or the vehicle for bringing a case to court and giving recognition to the case because of the transcendental importance of the question raised?
I think I remember one case, Southern Hemisphere, Your Honor. I think there was also a procedural flaw because I think, if memory serves, certiorari also was used by the petitioners. But the Ponente and the Honorable Court decided to just go to the merits because of the importance of the issues raised.
In the case of Tatad versus Secretary, what was questioned was the oil deregulation law, and the court recognized the petition. In Bayan versus Zamora, it was the visiting forces agreement that was declared unconstitutional. In Lim versus Executive Secretary, it was the Balikatan that was assailed. And so, it appears to me that you are bringing your case now together with the cases of the others petitioners because of this practice on the part of the court. While it does not technically conform with Rule 65, there are precedents to show that the court will recognize and give due course to a petition that does not exactly involve a ruling by a judicial or quasi-judicial body, right?
Right, Your Honor.
Okay. And in this, in your petition, you state that the petitioners have legal standing because they are taxpayers. What can you say about this?
Well, the legislation will involve the disbursement of public funds to the tune of billions of pesos. And I think it would be a waste of precious public funds if this law is to be implemented despite its unconstitutionality, Your Honor.
But jurisprudence says it can be questioned, the disbursement can be questioned only by one who pays his taxes, right?
Yes, Your Honor.
So, in your memorandum, can you show us how your client, the petitioners, became taxpayers? Okay, you also say that they suffered direct injury. Can you tell us what the injury was?
These are the individual petitioners there, Your Honor, are parents of 5 children, the Rodrigo family. And their children are going to school, and the mother is still in the reproductive age bracket. And the RH law speaks about these 2 important things, among others. The alleged reproductive health rights of a woman and the sex education issue with regard to the children. So I think they have enough standing and personal stake on this particular action, Your Honor.
What is the transcendental importance of this case?
First, this case, as mentioned by our opening speaker, former Senator Tatad, has divided the nation for so many years. And it's important that this issue be resolved one way or the other. Number 2, it affects the future, no less, of this country. In the sense that, as I was asked earlier with regard to the effect of population control on the long term, and that is the possibility of falling below the replacement rate, we are talking of not only of the present generation, but future generations yet to come. And therefore, I think it's important for us to emphasize that point, not also to ignore the transcendental importance of life itself, the right to life issue, Your Honor.
What other rights, fundamental rights, are involved?
Religious rights, equal protection, free speech, primary right of parents to educate and rear their children, rights of parents to found their family in accordance with their religious beliefs, right to health imposed upon the state. Your Honor.
So, to your mind, these are rights that are sufficiently important for this court to entertain this case.
I believe so, Your Honor.
Can you give me a rough outline for us, very, very briefly, the RH law? Outline for us, very, very briefly, the RH law. What are the various phases of the RH law in the 24 or so provisions that it contains?
May I describe it in terms of its characteristics, its underlying premises? One,
You can describe it in lay terms so that for now we can avoid and depart from legalism.
the RH law, I think, is a unique legislation. The country, especially the poor, are suffering from different kinds of serious illnesses. And yet no law, no special law has been passed by Congress to address diabetes, TB, cancer, heart disease. And yet, this RH law specifies a particular or targets a particular what they perceive to be a problem, which it is, and that is maternal death. They would like to reduce maternal deaths, which is well and good, but in the process, they have ignored the more important and more pressing problems, particularly of the poor. So this, I think, Your Honor, is one characteristic that is objectionable on the part of the RH law. Number two, the RH law, again, is so unique that it will harness the entire machinery of government for this particular issue of reducing maternal death and probably also, most likely, controlling population growth. Again, it's a very specific, narrow objective that does not take into account the bigger picture. As I said, we owe it to the future generations that the Philippines will continue on, not only for this generation to the next, but the remotest generations, in accordance with our obligation for posterity. But this RH law, if this ever gets passed, we know already because it happened in Japan, Korea, Singapore, Canada, Russia, and the European economies. They are aging. Less and less people are working. In fact, France underwent a lot of political turmoil because the government had to push back retirement because the expense is so huge. It's okay if we are rich, Your Honor. If we are Singapore, we can always attract migrants because we have jobs for them. But who will come to us? If there's not enough workers left to tend the field, left to man the factory, left to run the call centers, and yet to think that the same population which they consider to be a problem is the same population that allows us to export or deploy something like 11 million overseas workers whom we call heroes because they contribute an average of 23 billion to our coffers each year, Your Honor. So I think this RH law is a law that should be avoided. It's a law that we will have to answer for, not only in this generation, for the future generations to come, Your Honor.
And what approaches has the government used to achieve its objective for the RH law?
Simple, Your Honor. Flood the country with contraceptives. That's the only strategy that they have.
Flood the country? Is the government disseminating information?
Yes, that's part of the strategy to inundate, to propagate, to promote, and flood the country with contraceptives and develop a contraceptive mentality among the population, Your Honor.
And to compel people to follow the RH law, is it using the threat of penalties?
Yes, Your Honor. It's in Section 23. But may I also zero in on the poor? The poor are the actually victims of this RH law because they can't do otherwise. In the DOH program called Conditional Cash Transfer, 20 of the poorest provinces have been identified. These are the families living below the poverty line. They're getting cash dole-outs. But before they do that, they have to comply with certain conditionalities. Before this law, reproductive health services and information was not one of the conditions. But with this law, which integrates the RH law into the anti-poverty alleviation program of the government, it means that these reproductive health services and programs will become a condition before each of the poor families can get that 1,500 monthly subsidies. In other words, if you are using the direness of a person, this is poverty, as a way of getting him to participate in the program, in effect, you are coercing that poor person because that poor person has no choice at all. So I think there's a coercive element involved, Your Honor.
Would you give us a rough estimate when you speak of the poor? How many are the poor in our population?
According to statistics, if memory serves, Your Honor, at least 25 million are living below the poverty line. These are the people who can't afford to eat 3 times a day. These are the people who can't afford to get the medicine, to treat their bronchitis, their TB, their diabetes. These are the people who can't afford even to bring their children to school because although public schools are free, they need to spend for their transportation, for their food, etc. These are the poorest of the poor, Your Honor.
Of these 25 million, how many are women who stand to be directly affected by the RH law?
More than 20, if I remember correctly, more than 20 to 25 million are women of fertile age.
Or fertile age?
Yes, Your Honor.
And how many of these would be adolescents? Adolescents, as defined by the law,
Adolescents,
would fall under the ages of
10 to 19, Your Honor. Yes, Your Honor. I would not be in a position to give you the figures, Your Honor, but I would imagine quite a number, Your Honor.
Can you get government data and put this into your in your memorandum?
We will, Your Honor.
What I keep hearing from you is that the RH law has economic cost, right?
That's
But
correct.
there must be some other cost. Cultural, moral, ethical, social. And has the RH law addressed this, what I would call, hidden cost of its enforcement?
I don't see anything in the law, Lord, Your Honor, that will address that. In fact, to the contrary, the sex education, which I assume, because it's not written in the law, is intended to, for instance, curb teenage pregnancy. But we know, Your Honor, that the reproductive health law in the Philippines is just a copy of the reproductive law in the U.S., although there were some amendments after some haggling in Congress. But the spirit is still the same. And according to studies in the U.S., reproductive health law in the U.S., I think, was passed something like in the 60s, late 60s or early 70s. And from then on, up to now, teenage pregnancies continue to rise in the U.S. In fact, I have the data here, but I don't think we have to.
Can you just include that in your memorandum?
Yes, Your Honor, we will.
What about the use of contraceptives? Would the contraceptives be available only to married couples?
The law, I don't think, says that. In fact, in sex education, among the things that the children will be taught would be the reproductive health devices. They will be taught about condoms. In fact, we have I think a PowerPoint which shows the things that they will probably teach, how to wear condoms, and So I think, Your Honor, the alleged intended benefit that may be derived from sex education is not based on empirical evidence. Empirical evidence is that evidence that the United States, the mother of all reproductive health country, shows that it will actually result in the reverse, because young people will become more promiscuous and curious about sex.
Precisely, contraceptives are available to married couples and to single individuals.
Yes, Your Honor.
What is the effect if contraceptives are available to the individuals? They will not get pregnant, right?
Yes, Your Honor.
When a woman does not get pregnant, what is the possible effect?
Well, if the woman takes the contraceptive and the contraceptive works, then that achieves the purpose. But the problem is, what if the contraceptive, which has a significant failure rate, does not work? In the beginning, the very premise of the couple is that the woman should not get pregnant out of that sexual act. But if she does, the possibility of avoiding that pregnancy comes to the fore. Because from the beginning, that has never been the intention.
Assume that the contraceptive works. Would that mean that the single individual can continually engage in sex without fear of pregnancy?
Using contraceptives, Your Honor?
Contraceptives, yes.
There is a chance that, yes, she can without getting pregnant. Although there is also a chance that she might get pregnant. But what is also to be mentioned is that every time she uses contraceptive, she exposes herself to health risks. The risk of cancer, according to the US DOH, they tallied the causes of cancer among women. Number one is breast cancer. And according to the United Nations International Agency for Cancer Research, the use of oral contraceptives, particularly the combined type of estrogen, progesterone, increases the risk by between 30 to 60%. So if a particular woman is predisposed to cancer to begin with, meaning she has an inherent risk of 10%, you add 30 to 60%. And that's the amount of risk that person is taking when she takes on the pill.
You're speaking of health costs. What about in terms of morality? What would be the effect of the use of contraceptives on morality?
It will develop a mentality that it's okay to have sex, provided it is safe. And I think that's the underlying premise of this RH law. And a contraceptive mentality, as shown in the US and other advanced countries, will always result in difficult moral and social and psychological problems, Your Honor. It obviously could encourage promiscuity, since there is now liberty to engage in sex without being exposed to the consequences of that act.
How would this affect the family?
If you have a contraceptive mentality, Your Honor, and there is the thinking that if you use contraceptive, there will be no pregnancy, it might be easier for a man, a husband, to actually engage in adulterous relationship because there's no consequence anyway. Unlike if there is no contraceptive mentality or if there is no such law promoting it, even if that husband might think of philandering, he would have to think twice because there is always that risk that that other person might get pregnant.
What if it is the woman who engages in extra marital sex?
It's more incriminating, Your Honor, because she will bear the evidence of adultery.
So what is the overall effect on morality?
It could result in the breakdown of immorality as we have shown in the U.S., Your Honor.
If that happens, what is the effect on the family?
It will undermine and weaken the Filipino family, Your Honor.
Would this be consistent with what the Constitution and this law says about strengthening the family?
No, Your Honor, because the family is the foundation of the nation according to our Constitution.
So, RH law is an anti-family law, right?
Right, Your Honor.
Is the effect of the RH law on culture?
Your Honor, what is unique about the Filipino culture is that we are heavy on family. We value family. We value being among or with our family. We value the future of our children. We value our religious beliefs. We value things that other rich nations do not anymore value. But if we allow this law to pass, it might open the floodgates, Your Honor, for our unique, precious values to be threatened and eventually to be assaulted by this Western-sponsored culture that obviously is not suitable to our culture.
If the present generation of adolescents are fully exposed to the RH law and the culture that it encourages, what do you think will happen to the next generation?
Well, I think we already have a picture. The picture of the U.S., where children don't respect their parents, where according to the studies that we have, which we will submit with our memorandum, young people as young as 12, 14, up to 19 engage in multiple sex, Your Honor. That's the kind of future that we face if we allow this portal called RH law to be opened and expose our young and the future generations to this kind of pernicious cultural phenomenon, Your Honor.
Counsel, culture simply means the way of doing things, the way of thinking, the way of acting or reacting by a group of people. Do Filipinos have this unique way of thinking, acting, reacting?
Yes, Your Honor. I think our culture is unique to us. That's why we, as I said, we sometimes even to a point of being subservient to others because of the culture of, which is I think basically Asian. We are so close-knit. At the same time, we are, to put it in a word, old-fashioned. Now, is that bad? If we're talking of good values, I think that's good. But if what the RH law means of looking forward to the future and being modern, I think that's not the way to go for us.
Is promiscuity a part of our culture?
No, Your Honor. I think it's a great shame for a person, the average Filipino, to be engaging in promiscuous act, Your Honor. It's against the teachings that they listen to and receive in the family. The family is the beginning of education. And our family is generally old-fashioned, very conservative, and for the most part, very Catholic. We value religion, we value things that our old folks value, and I think it's important for us to carry on these values to our generation and to future generations, Your Honor.
Even the RH law potentially will affect also our values as a people.
Yes, Your Honor, very adversely.
Does the RH law have anything within its 24 provisions to address this?
If Which one? The values, Your Honor? I don't think so, Your Honor. In fact, the very essence of the law is violative of those values because it will promote, as I said, promiscuity. It's okay to have sex provided it's safe. That's the essence of a contraceptive mentality, Your Honor.
So is it worth to pursue the RH law, considering all these costs?
I think it's not worth pursuing this law. Anyway, there are laws that protect maternal health. The Magna Carta is already there. In fact, the good provisions of the RH law are in the Magna Carta. The only thing that is lacking in Magna Carta are the coercive provisions, particularly the criminal sanctions.
Is the RH law, in that sense, consistent with matuwid na daan?
I don't think so, Your Honor, because matuwid ang daan means that it's a path that will lead you to something bright, something promising. But if you are imposing a contraceptive mentality, it will not affect only this generation, but the future generations to come. At some point, if I may offer some personal trivia, I do pre-Cana in our church. And the one question that I will always ask is, how many children would you like to have? To a man. They would say 2 at most. Even without this law, they have already brainwashed the young because of the schools, because of the subtle teachings that were imposed by the originator of this RH law. So what I'm saying is that given the mentality, the present mentality and makeup of this young, if you introduce reproductive health, it's almost a certainty that that many of, or some of them might consider, might even be less. If a man marries a woman, the minimum obligation of that couple is to make sure that that woman will give birth to at least 2.1 to ensure the continuity of that family and projecting it to the nation as a whole, to make sure that our race will continue on, not only for the next generation, but for the future generations, because that is our obligation to preserve and maintain our posterity.
Of Section 7 in relation with Section 23A-1. Are you aware that under Section 7, after a referral and there is a consensus objector, then it can be referred to another facility that is accessible, right?
To a Catholic, it's not acceptable, Your Honor.
No. Not acceptable, accessible.
Accessible, yeah.
Accessible.
Sorry, Your Honor. Yes.
A facility that is not that is accessible.
That's correct, Your Honor.
What happens if there is no facility that is accessible?
Although that's a possibility, Your Honor, if you read the law, the entire machinery, the entire structure of government will be harnessed down to the smallest barangay because the LGUs will be mobilized. So the possibility of a person asking for reproductive health services or information, not being able to get it after an objector has declined him, is a bit sort of improbable.
Still in the last paragraph of Section 7, it says there, no person shall be denied information and access to family planning services, whether natural or artificials. And if there is no accessible facility, would it not that the conscientious objector might still be compelled
No, Your Honor. Because
to do what he does not want to do?
He cannot be compelled because that will violate the most inalienable right in our Constitution, and that is religious freedom. even if we weigh the competing interests, there is no contest because this person asking for reproductive health service or information is not in an emergency situation. That is the premise, Your Honor. On the other hand, the conscientious objector is being made to choose between following his beliefs and facing the criminal sanction or avoiding the criminal sanction and forsaking his own beliefs. The gravity of the choice is obvious in the case of the conscientious objector. But what does a person seeking reproductive health services, what will he lose if he is declined the information? As I said, considering the overwhelming propagation intended by this law, there is little possibility, if at all, that he will not get it. But even if he does not get it today, since that provision, actually two provisions, speak of a non-emergency situation, he will always have the time to look for another reproductive health provider to give him that information or service.
I will sum up, Counsel, with this question. By resisting the reproductive health law, are you now effectively towing the line ang matuwid na daan?
It's a contradiction in terms, but I think if by resisting the law, I will actually be following the narrow path, the narrow and straight path, Your Honor. Thank you, Your Honor.
Justice Velasco.
Counsel, can you clarify what is your position on what family planning methods are to be outlawed or any provision on that will be declared unconstitutional? Will this be family planning methods that prevent the fertilized ovum from implantation in the maternal womb? Or do you want a provision that allows distribution of family planning methods that prevent fertilization of the ovum? Can you clarify your position on this?
Well, definitely, Your Honor, we cannot allow, we will resist, we will object to the propagation of abortive fashions. Now, with regard to...
But that's in the law. That's
in the law, yes, Your Honor.
It is prohibited, right?
That's correct, Your Honor.
Okay, so what's your view, your position on the other query? Whether a provision that allows distribution of family planning devices or drugs that prevent fertilization of the ovum should be declared unconstitutional?
Yes, Your Honor, because first, as we've mentioned, even contraceptives, meaning those that are not abortive fashions, pose some risk to a woman.
Counsel,
And if-
give me first a categorical answer. Are you asking the court to declare a provision that allows distribution of family planning devices or drugs or other methods that prevent fertilization to be unconstitutional?
Yes, under Article 2, Section 15, the obligation of the state to protect the health of its people, Your Honor.
Is that contained in your petition?
Yes, Your Honor. That's correct, Your Honor.
So this is a different position than that taken. Sorry. Please correct me, but I think Attorney Noche made a different proposition when she made her presentation. So you have a different proposition now. So you are saying that all these family planning devices, drugs, and methods, or any provision on that allows distribution or use to the people has to be declared unconstitutional. Is that your position now?
Yes, our position is that even contraceptives, the propagation, if it is especially state-sponsored, as it is in the RH law, will violate the duty of the state under Article 2, Section 15, to protect the health. It will also violate Article 2, Section 12, which requires the state to protect equally the mother and the unborn from conception. So, in other words, what we're saying is that, yes, even non-abortifacients, because of the fact that they pose health risks to the women, will have to be objected to on the ground of Article 2, Section 15 and Section 12.
No, we are referring now to non-abortifacients because you admitted that abortifacients are prohibited under the RH law, and so there's nothing wrong about that. Is that correct?
Yes, it's prohibited. Yeah.
All right. So we're now talking about non-abortifacients, and your proposition now, although I'm not sure if that's really contained in your prayer, is that this provision that allows distribution and use of these non-abortifacients that prevent fertilization of the ovum should also be declared unconstitutional.
Yes, Your Honor.
Is that clear now?
Yes, Your Honor.
Okay. Then, practically all family planning drugs, devices, and methods covered by Section 7 will have to be outlawed. Practically all. Right?
Since they are harmful, yes, Your Honor, because that will violate the duty. Our main point is this, Your Honor. These non-abortifacient drugs are available in the market. But what the RH law does is for government to be the initiator, to be the prime mover, to be the financier. It will buy, it will distribute, it will promote these contraceptives to the population. And we are objecting to that because that contradicts Article 2, Section 15, which clearly obligates the state to protect the health of the population.
So is your view that if it is the government that will distribute and supply these family planning methods, then that should be declared unconstitutional?
Yes, Your Honor.
But if it will be private groups, NGOs, or private persons, like the Condom King in Thailand, that's okay.
That's okay because there's no prohibition for a private individual.
As long as these are non-abortifacients.
Yes, Your Honor.
Okay. So, on that premise, you're saying Section 7 should be declared unconstitutional because it is provided there that all accredited public health facilities shall provide a full range of family planning methods, right?
Yes, Your Honor.
That is your basis.
Yes, Your Honor.
You're aware of the administrative code, right?
Some
Are you
of it,
familiar
some
with that?
provisions, yes.
Are you familiar with the duties and functions of the Department of Health under the administrative code?
Little bit of the enumeration probably, yes, Your Honor.
Yeah, I'm asking you about that because if Section 7 will be declared unconstitutional, then necessarily Section 3, Item 2, in Title 9, Chapter 1 of the Administrative Code on the powers and functions of the Department of Health may also be challenged as unconstitutional. And I read to you that particular function of the Department of Health. And it says, the department shall, and this is Item 2, provide for health programs, services, facilities, and other requirements as may be needed subject to availability of funds and administrative rules and regulations. So even without Section 7, the Department of Health can distribute these family planning methods. And as a matter of fact, the department may have been doing that. So with the declaration of nullity or unconstitutionality of Section 7, this may lead to an examination of Section 2, or rather Item 2, Section 3 of Title 9, Chapter 1 of the Administrative Code as also unconstitutional?
Your Honor, from what I heard, that provision speaks of health products. Our position is that contraceptives are not medicines. They are not medicines. Their reason for being is not to cure. If there may be incidental effect of curing, it's only incidental. Its main and only purpose is to avoid pregnancy. It is not treating a particular illness, Your Honor. So I think that provision may not be related to our position that the RH law violates Article 2, Section 15 because that provision obligates the state to protect the health of the people.
So you're trying to harmonize the
Yes,
two
Your Honor.
provisions.
Yes, Your Honor.
So we can declare unconstitutional Section 7, but under Title 9, Chapter 1, on the powers and functions of the Department of Health, it is not supposed to distribute family planning methods, right?
Yes, Your Honor.
So what the Department of Health is doing right now, which I think is the distribution of these family planning methods, contraceptives, and other supplies, may be unconstitutional. It may also be challenged. Is that correct?
Yes, Your Honor. If they will distribute the same way that the RH law will obligate the Department of Health to distribute to the poor, I think, yes, they will run afoul of Article 2, Section 15 of the Constitution.
Well, of course, this is offered to all walks of life. People, maybe average income family, coming from average income families, or the poor, or even the rich. So, Department of Health may be really distributing these family planning methods now to the poor, right?
Right,
The
Your Honor.
marginalized. Okay. There is nothing illegal about distribution of contraceptive drugs or devices, right?
If it's done by private individuals, I don't see any problem there, provided
it's
they are
done.
not abortive actions, yes.
Of course, we have a law on the use of contraceptives, right? Republic Act 4729.
Yes, Your Honor.
And it says that these contraceptive devices and drugs can be sold only with the prescription of a qualified medical practitioner.
Yes, Your Honor.
Okay? So, Republic Act 4729 is not in any way, will not be in any way affected by the declaration of unconstitutionality of the entire RH law?
Maybe not, Your Honor, because there are safety measures there. The condition that contraceptives shall only be dispensed with or upon prescription coming from a licensed physician might be enough safeguard, Your Honor, because the foundation of Article 2, Section 15 is the duty to protect. And that requirement for prescription might serve as the protection device.
Is it really your position that all these provisions will have, or rather the entire law will have to be declared unconstitutional?
Yes, Your Honor.
Don't you think that some provisions can remain unaffected by any declaration of nullity? Like, for example, Section 8, maternal death review and fetal and infant death review. There's nothing wrong about that.
There's
right?
nothing wrong with that, but the Magna Carta already takes care of that, Your Honor.
So
there's
this is a redundancy, right?
Yes, Your Honor.
Okay, well, we have to look into this clearly. How about the Section 15, Certificate of Compliance for people who want to get married? Is there anything wrong about that if they are given a seminar on family planning, breastfeeding, and infant nutrition? Is there anything wrong about that? Or is this covered by another law also?
No, there's a constitutional provision that might be transgressed or infringed by that additional requirement.
So you're saying we should not require the couples
because
who intend to get married to undergo the seminar on these matters?
Yes, because it creates another condition, making it difficult for them to actually contract marriage. And what is wrong with that provision is that it gives the issuing officer certain discretion because it says he will certify that adequate instruction have been given. Adequate is a very subjective term. There is an old law actually that covers something similar, PD 956. But that law does not give any discretion on the issuing officer, unlike the RH law under Section 15, Your Honor.
I again refer to the powers and functions of the Department of Health, and under Item 6, Section 3 of the same Title 9, Chapter 1, the department has the duty to propagate health information and educate the population on important health, medical, and environmental matters which have health, medical, and environmental which have health implications. So, you're saying that this does not empower the Department of Health to, or rather, the state, or rather the Department of Health to provide information on family planning methods. This will not be a sufficient basis for the Department of Health to provide information on family planning methods.
If the premise, Your Honor, is that contraceptives are potentially harmful, yes, I would think so, Your Honor, because again, it will collide with Article 2, Section 15 of the Constitution.
Are contraceptives really harmful? Or why is it being allowed by Republic Act 4729? Why is it being allowed but subject to regulation?
That's the point, Your Honor. It is self-evident. The fact that the former law, actually it's the pharmacy law, I think that is 4729. The fact that it requires prescription from a duly licensed physician tells us that it is harmful if taken without supervision, because you need to know any underlying risk factors that person might have that might aggravate his illness, pre-existing illness. I think that's a good evidence that these contraceptives could be harmful.
So, the 4729, Republic Act 4729, may complement whatever provisions of RH law that refer to contraceptives, correct? That's a possibility. So, when you give contraceptives, it has to be under the supervision of a qualified medical practitioner.
I think there is a repealing clause, Your Honor, if I remember correctly, in the RH law.
In the RH law?
Yes, so that means that 4729 might be deemed repealed because there is
being inconsistent.
Yes, very inconsistent.
Okay, but you want the entire law declared unconstitutional anyway.
It has no point, Your Honor. It doesn't serve anything because whatever good points it might have, the Magna Carta already has it.
Okay, that's all. But can you put in your memorandum what provisions here in the RH law have similar provisions in the Magna Carta?
We'll do that, Your Honor.
Okay, and that, can you explain clearly also why all the provisions have to be declared unconstitutional? Because to me, my view right now is that there may be some that may remain constitutional while probably some may be declared unconstitutional. Thank you, Counsel. Thank you.
Mrs. Leonen.
Assalamualaikum wa rahmatullahi wa barakatuh. I greet you in Arabic because maybe it's the holy month of Ramadan, and I think it's also important for us to remember that there are other religions in our country. Is that not true, Counsel?
That's correct, Your Honor.
Would I be wrong to say that the reason why you are opposing this law is because it is not Catholic enough?
No, it's because it violates our Catholic teachings, Your Honor.
Unconstitutional because it violates the Catholic teachings?
Yes, Your Honor, and that is guaranteed under the Free Exercise Clause of the Constitution.
Wait a minute. You are saying that it can be unconstitutional simply because it violates the Catholic doctrine?
Yes, it can be unconstitutional on that basis.
Do we have separation of church and state, Counsel?
Yes, Your Honor.
And the state is the Catholic doctrine?
No, Your Honor.
So there should be a difference between what the state says and what the Catholic doctrine may say. Is that not true?
That's true.
Yes, and therefore, you cannot expect this court, a secular one, we are not the congregation of the faith, nor the Darul Ifma, that we should declare it unconstitutional on the basis of a view of a religion. Is that not correct?
I beg to disagree, Your Honor, because while the majority of the law is secular, the provisions that we are objecting to, particularly Section 7,
So your position
Section
is that there
23.
is a violation of the Constitution simply because it violates Catholic doctrine.
no, it violates religious freedom. It happens that the
freedom.
objector is a Catholic, Your Honor.
And everything that the Catholic doctrine says must be in the law, or should not be should not be contradicted by the law.
Oh, we're not saying that, Your Honor, because
Can
if
you
there
give
is a
us
compelling
the
state interest,
existing constitutional test for determining whether the concerns of a religion may be taken into consideration in relation to a secular objective?
can you repeat that, Your Honor?
Can you give us the existing constitutional test to determine whether doctrine of any religious faith should be given consideration in relation to a secular objective?
The latest is your decision, Your Honor, in Estrada versus Escritor. Before that, Ebranilag,
In
wherein-
Estrada versus Escritor, would you know the voting of the court?
I think it's a close call, Your Honor. But
Is it enough to establish ratio decidendi?
I think if the en banc decides on that basis, then it should be law.
I mean the number of votes. Are you sure that there was 8 votes in favor of the ponencia of the Chief Justice, then Justice Puno at that time?
I don't know, Your Honor.
There was none. In fact, there were 2 separate opinions and very strong dissents by 5 members of the court. Is that not correct?
Could be, Your Honor, because
So,
it's not published.
What would be the precedent that we can use? As far as we are concerned, we are supposed to follow the Constitution, and Article 3, Section 5 does
Yes.
say that there are 2 important parts to religion and the state. One is non-establishment. Let's just do away with that. This has nothing to do with the non-establishment clause.
That's
it.
correct.
Yes, because as far as we are concerned, there is no religion that is being favored by this particular law. Is that not correct?
That's correct, Your
So we
Honor.
go to the second part, the free exercise of one's religion, correct?
Correct.
And in many instances in the past, here, abroad, many other jurisdictions, there have been conflicts between religious doctrine and secular objectives. Is that not right?
That's right, Your Honor.
Yes. And again, may I ask, what, for our guidance, what do you think is the existing standard that the court uses to determine whether the secular standard becomes dominant or it is the religious expression that becomes dominant?
I think the test should be, if you're saying, Your Honor, that Escritor is not effective as a stare decisis, then your decision in Ebranilag should provide a test, which is
That's
grave
the-
and imminent danger.
Again?
In Ebranilag, I think the court said that only a grave and imminent danger,
In Ebranilag?
yes, I think so, will override religious freedom.
Perhaps you can cover this in your memorandum.
Yes, we will, Your Honor.
Definitely, are we in agreement that we cannot declare it unconstitutional for the Catholic Church?
That's correct, Your
That's
Honor.
correct. Neither can we declare it unconstitutional for Islam,
Of course, Your Honor.
because we are, of course, a secular court, and we are looking at the Constitution, and as far as we are concerned, there is separation of church and state.
Yes, but you have the duty to apply the Constitution, Your Honor,
Definitely.
including the free exercise clause.
Definitely, we took an oath to it, and definitely, of course, there are problems in relation to the intersection of religion and the secular objectives of the state.
Yes, Your Honor.
Yes, and you will help us in your memoranda clarify where the test is and apply it to this particular instance. Is that not correct?
Yes, we will do that, Your Honor.
Thank you. Are contraceptives dangerous drugs?
The studies say so, Your Honor.
Because there are contraindications whenever you use contraceptives, right?
That's an indication
Yes.
that it could be harmful.
Okay, here is a drug. These are the contraindications. Liver enzyme abnormalities, persistent elevations in hepatic transaminases can occur. This is so dangerous, I cannot even read it. skeletal muscle effects. Example, myopathy, rhabdomyolysis. You know what this drug is?
No, Your Honor.
It is rosuvastatin calcium, otherwise known as Crestor.
Crestor, I'm
You know
taking
what?
that, Your Honor.
Yes. Do you know that it's a dangerous drug? Because
Yes.
there are contraindications.
There are contraindications,
But
you're
we do
correct.
not ban it simply because it may have side effects, correct?
Yes, because it is a unique medicine, like a contraceptive, Your Honor. It serves a purpose.
Okay,
because
here's another drug. The contraindications are hepatitis, acute liver failure, giant hives, decreased blood platelets, decreased white blood cells. This drug is called paracetamol. So it has those contraindications too. So may I just clarify, because you did in some interpellation a while ago, say that it is dangerous to one's health, these contraceptives, because it has contraindications. Now, are we saying that just because technology produces drugs or certain methodologies which always have a side effect, that it should be banned by the state?
Your Honor, the premise is the two examples that you gave are actually medicinal curative. The contraceptive is not of the same league. It does not serve to cure anything. Even paracetamol serves a curative purpose. Crestor more so. But not quite
But then again,
with a contraceptive.
but
They are
then
not
again,
medicines.
The law says in Section 9 that in spite of the fact that your claim is that it is not medicine, of course you will cover that in your memoranda, that it does say that it has to go through testing at the FDA level, and there will be also public hearing in order to determine its side effects or whether it should be banned or whether it should not be offered to the public. Is that not correct?
Section 9 appears to contradict that statement, Your Honor.
Why?
Section 9 preempts the FDA practically because it says, Section 9 reads, the National Drug Formulary shall include hormonal contraceptives, intrauterine devices, injectables, and other safe, legal, non-abortive fashion and effective family planning methods. In other words, the very law classifies the preceding contraceptives as safe.
Is
So
it
in other words,
possible
sorry,
that
Your Honor.
hormonal contraceptives here is a generic? It means that each and every manufacturer, each and every drug, pill, that claims to have hormonal contraceptives in it must undergo testing under the FDA.
But how can you reconcile that when the law itself says they are
I ask
safe?
that you answer the question.
Yes, Your Honor, sorry.
We're just getting some clarification
Yes,
to
Your
help
Honor.
us aid in our decision. And I'm not here to debate with you.
No, I'm sorry, Your Honor.
Yes, we are here to clarify matters. Is it possible that hormonal contraceptives here refer to a generic? That each and every pill which appears to be or claims to be a hormonal contraceptive must undergo testing with the FDA?
Yes, if that's the
Is it
premise,
possible, because it has to undergo testing with the FDA, that at the end of the day, if you are right, that none of them can be approved by the FDA?
Yes, Your Honor.
Yes. And therefore, would you agree with me that it might be too premature at this time for us to say each and every pill manufactured by any manufacturer company is now an abortifacient or should not be allowed? Or that we take a drastic action of declaring this as unconstitutional without going through the process outlined in Section 9?
If you read the provision, Your Honor, it seems that the FDA, as I said, is not given the discretion to examine the properties of these hormonal contraceptives as probably being unsafe. The law itself says
Is there a
that they are safe.
manufacturer that calls the drug itself as hormonal contraceptive? Is that the name given, or is that the generic label? Like, for instance, paracetamols, or for that matter, headache relievers, correct? And in each of these particular cases, the particular manufacturer undergoes the procedure. Is that not correct?
That's correct, Your Honor.
Now, let's go to another point. Do we have the power to declare a law as unconstitutional because we thought that the Congress should have a different priority for its time? Again, may I repeat? do we have the power to declare a law as unconstitutional because we think that Congress should have attended to another evil prior to this particular law?
No, Your Honor.
So
You're-
for that matter, you did say that there are other diseases out there
Yes,
that
Your Honor.
Congress should have covered with more all-encompassing law. That cannot be the basis for us to declare the RH law as unconstitutional.
I mentioned that in the context of equal protection, Your Honor.
How-
Because if it is true that the premise of this law is to prevent maternal deaths, and that has been repeated many times over in the media and even during
Yes, again.
deliberations.
If Congress wants to attend to maternal deaths one at a time, but not all at the same time, because it cannot, it has to take priorities, right? Can we declare a law as unconstitutional simply because, in our opinion, we unelected members of this government, that government should have taken care first of, let us say, malaria or tuberculosis, etc. Can we declare that law as unconstitutional? Even
Yes.
under equal protection.
Even under equal protection, and also in obedience to the duty of this honorable court to determine whether Congress has gravely abused its discretion or acted arbitrarily. I think that's the point of the petitioners, Your Honor.
Okay. You mentioned the conditional cash program a while ago as part of your argument. Is that pleaded in the pleadings that you submitted to the court? Your allegation that the RH provisions have already been incorporated in the conditional cash program, because that's a very serious allegation now that we have an SQA. Has that been pleaded in your pleadings?
In general terms, Your Honor, in the petition of Couples for Christ, I think it was mentioned as one of the grounds, Your Honor.
Okay. Now, does this court have the power to police sexuality?
No,
I mean,
Your Honor.
The choices of people, whether they should have sex or not have sex, whether they should have sex with one partner or 1,000 partners, does this court,
No,
does
Your
the
Honor.
Constitution have the power to regulate that?
No, Your Honor.
Okay, thank you. Now, let's just go to more specific provisions. Do you have the law with you, counsel?
Yes, Your Honor.
Can you help me? Can you read Section 3, Paragraph 8?
Section,
3, Paragraph 8.
paragraph 8, Your Honor.
Yeah, A, as
A.
in apple or alpha. Sorry, or atis.
Section 3 reads,
A.
guiding principles for implementation. This Act declares the following as guiding principles. A, the right to make free and informed decisions, which is central to the exercise of any right, shall not be subjected to any form of coercion and must be fully guaranteed by the state, like the right itself.
Okay. Can we go to Section 23, the penal provision, subparagraph letter B, as in Bravo?
Any public officer, elected or appointed, specifically charged with the duty to implement the provisions hereof, who, personally or through a subordinate, prohibits or restricts the delivery of legal and medically safe reproductive health care services, including family planning,
The next clause is important.
or forces, coerces, or induces any person to use such services,
Any public officer, elected or appointed, who forces, coerces, or induces any person to use such services which refer to reproductive health can be criminally punished. Is that not correct?
Yes.
Fair reading.
That's correct.
So
yeah.
no public officer can coerce a person to actually make use of artificial contraceptives. Is that not correct?
That's correct, yeah.
Yes. Letter C. As a matter of fact, can we read it? Same.
Same section. Any employer who shall suggest, require, unduly influence, or cause any applicant for employment or an employee to submit herself to sterilization,
Use any modern method of family planning or not use such method as a condition for employment. That too is a crime, correct?
Yes, that's correct.
Now, will you agree with me that there is no compulsion under this law for a woman or a man to make use of artificial contraception?
You mentioned, as a general answer, yes, but I mentioned
No,
the
we
unique...
can only go by the text of the law.
Okay,
because,
but the text of the law.
we can engage in moral argument or ethical argument or religious argument, but we might be wasting the time of this court because this is a court of law again. Again, as I said, the text, does it compel a woman, even a poor woman, to actually make use of artificial contraceptives?
By its text. Yes, Your Honor, it does not.
It does not. You said by its text. What else is there?
I mentioned the unique experience of the poor through the integration of the anti-poverty program. And
Wait, are we attacking the anti-poverty program now? or
no,
is-
Your Honor.
Okay. Now, can we move on to, again, since you have the law with you, Section 3, subparagraph L,
I'm
as
sorry,
in
Your Honor. Section?
L. 3, subparagraph L, as in Leonen.
Active participation by
No, Section
L.
3, yes.
Okay. There shall be no demographic or population targets.
There shall be no demographic or population targets.
Yes, Your
And
Honor.
the mitigation, promotion, and or stabilization of the population growth rate is incidental to the advancement of reproductive health. Will you agree with me that this bill is not for population control?
I'm sorry, I will not agree, Your Honor, because
Why?
that provision is precisely qualified by an admission that the effect of reproductive health program is to mitigate and stabilized. I think the dictionary Webster will define or defines mitigation as the lessening of a particular impact. So if you read the law, logically, it says that, okay, we will not have any population targets, but the effect of this is to mitigate and manage population growth. To me, it says a lot about an attempt to control population, Your Honor.
Is incidental to the advancement of reproductive health. Isn't that a phrase also in the text of the law?
Yes,
Yes.
but it also admits that that is a necessary consequence of the reproductive health program.
By the way, counsel, who dies when we say maternal mortality? Is it the man that dies or the woman?
The woman, Your
The
Honor.
woman. Who gives birth? Is it the woman or the man?
The woman, Your Honor.
And in terms of maybe reproductive stuff or reproductive health, what's the participation of the man? You don't go into graphics, just maybe in general. Simply to partner with the woman, correct? And produce the element, the sperm, in order to be able to fertilize the egg. But it is the woman that carries the ovum and the fetus for 9 to 10 months, depending on how long the term is, correct?
Correct, Your Honor.
Yes. And the equal protection of the law does not mean simple equality, correct?
Yes, Your
It
Honor.
means looking at the just deserts, meaning to say looking at what should be allocated to people with the most burden, correct?
Equal protection, Your Honor?
Yes. In terms of maternal mortality, it's the woman that dies, correct?
Yes, Your
And
Honor.
therefore, there should be a law which actually helps out protect the health of women as they give birth. Is that not correct?
Yes, Magna Carta actually addresses that.
More than any law that should protect the man in terms of birth giving, because the man has very little participation.
That's correct, Your
Not
Honor.
correct. Okay. Now, in terms of information, who has more information, the rich or the poor?
The rich, probably,
The
Your
rich
Honor.
has more information. Does this law have a bias towards providing more information to the poor?
I think so, Your Honor.
Yes. And again, does this law compel anyone to actually make use of any of the methods that are presented to them?
Integration clause might suggest that there is coercion, Your Honor.
Which clause?
The provision that the reproductive health program, family planning, will be integrated into the poverty alleviation program
But
government.
it's a crime. Any public officer who forces or coerces, correct? So that therefore would come within the provisions of the law, correct?
That's correct.
So therefore, is there any compulsion for a poor woman, given the information, to actually make use of artificial?
I think so, Your Honor.
How is that again?
Because we're talking of the poor. They have no choice. They need the 1,500 peso cash dole out every month. And one of the conditions...
Again, counsel, we are looking at the RH law, not the conditional cash transfer program. Here, I don't see the 1,500.
But I see the integration of the poverty alleviation program. I think this honorable court can take judicial notice of that.
This judicial notice concept, it is to take notice that there is 24 hours in a day. Is that not correct? Or that the
Yes.
sun rises and sets, correct?
That's right.
But there are certain truths that may be believed by some people which may not be truths of others. Is that not
That's correct. That's correct. Yeah.
And the gold standard might be science. Is that not correct?
Among others, yes.
And as I asked, I think the other counsel at the other time, would you agree with me that the science on both sides are robust? That there is science quoted by the petitioners, and there is also science quoted by the respondents? Or would you say that their science are false?
Are you referring, Your Honor, to the issue of right to life?
Generally.
Because I'm referring to a specific situation here, provision that integrates the poverty alleviation program in the...
No, I went on. I moved on.
I'm sorry,
In
Your
terms of the
Honor.
question. This issue of judicial notice, can we take judicial notice of a fact that is contested by several scientific associations, organizations, and the findings are still, shall we say, being debated upon?
No, Your Honor.
Okay, thank you. Let us take a look at Section 14, which is part of your oral arguments. And this has something to do with education, correct?
Yes, Your Honor.
Yes. Section 14 says two things. One, age appropriate and developmentally, I'm sorry, can you read that portion?
Development appropriate. The state shall provide age and development appropriate reproductive health. It's education.
Not only that, it says to be taught by adequately trained teachers.
Yes, Your Honor.
Not only that, it says that it can be integrated into several different types of courses in the curriculum, such as values formation, knowledge and skills, self-protection against discrimination, sexual abuse. Not only that, it does say that the DepEd shall formulate a curriculum used by public schools and may be adopted by private schools. And finally, that only after consultations with parent-teacher community associations, school officials, and other interest groups will the course be actually established.
That's correct, Your Honor.
Yes. What's wrong with this?
I said there are at least three constitutional violations for that provision, Your Honor. One, it violates the equal protection. Why? Because it makes sex education mandatory public schools, but optional in private schools. The effect of which is, with regard to parents of children in public schools, they will have no choice but to accept sex education for the children.
Is there no reason why it is mandatory in public schools and optional in private schools?
Whatever the reason, it does not qualify as a valid classification, Your Honor. Because if the purpose of sex education is precisely to educate the children and students about reproductive health, then it should apply equally to all the students, regardless of whether they are in public or private schools.
So there should be sex education mandatorily provided in private schools?
No, what we're saying is that it has to be optional, because there's another constitutional provision being infringed.
Which
the
is?
right of the parents, the natural and primary right of the parents to rear their children for moral development.
So because there is the natural and primary right of the parent to teach their children sex education, the schools cannot teach it?
They cannot. Because the state's obligation is to support. In the old Constitution, I think 73.
As a matter of fact, I should be able to teach my daughter law. Therefore, schools should not teach law. Can we follow that logic, Counsel?
No, because law has nothing to do with
Is it not
beliefs.
possible that the schools simply supplement the values already created in our children by us and by our churches? And the only thing they try to do is try to supplement whatever the parents may not know yet about sex education.
Compulsory sex education, Your Honor, is not supplementing. It is actually usurping the primary right of parents to educate.
Does it say here that the parents may not teach their children sex education?
But it does not. But it preempts because
Does it say here that our churches may not proselytize on values that are embedded in the sexual act?
it is implied, Your Honor, that that
Therefore,
right will be undermined
Is
by
there a
this mandatory
violation of
sex.
such rights by the family and all, by the church, of such rights by an institution of a religion?
I'm sorry, Your Honor.
If it is not prevented here in the law, all it says is that it provides courses for sex education, but it does not say that the parents may not teach
Yes,
sex education.
the problem is that it is mandatory. The fact that it is mandatory immediately takes it out of the primary duty of parents to educate. Primary means the chief, the initiating, the first. What
Yes.
this mandatory requirement
At 3
does.
years old, your children are with you. You teach them first. At 4 years old, you teach them first. When they come home, you teach them. When they're adolescents, you correct their mistakes. That's primary role, correct?
Except that our children spend more hours in school
Again,
than
may
at
I
home.
ask, is there anything in Section 14 which actually says that the family may not continue to teach their children?
There's none, Your Honor.
Okay, thank you. That's all, Chief.
Trustee Castro. You mentioned some provisions of the law which you think have an impact on the freedom of religion.
That's correct.
Now, on another matter, it seems that when life begins, it's no longer a religious matter insofar as the Constitution is concerned, because the Constitution has elevated this to a constitutional principle that life begins from conception.
That's correct, Your Honor.
Now, from scientific studies, it would seem that the fertilized ovum or the fertilization of the ovum occurs in a matter of minutes, and that the fertilized ovum undergoes a series of development of and by itself
Yes, Your Honor.
before it is implanted in the uterus. Now, let's go now to the definition of abortifacient under the law. It says that abortifacient refers to any drug or device that induces abortion or the destruction of a fetus inside the mother's womb, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb upon determination of the FDA. Now, abortion is not defined here as to what is meant by abortion, which is induced. It is followed by a phrase referring to a fetus. So clearly that does not refer to the fertilized ovum. Now, and the third part refers to the fertilized ovum, which is prevented from reaching or be implanted in the mother's womb. What about the condition of the ovum from the time that it is fertilized up to the time of implantation, which may take many hours or perhaps days? Why didn't the law simply says that an abortifacient is one which will destroy the fertilized ovum?
That's a good definition, Your Honor.
But it would seem that the law is more restrictive. It refers to the prevention of the fertilized ovum to reach and be implanted in the mother's womb. So it would seem that it is not protected before the time of implantation. Is that a fair interpretation of this provision?
That it is not protected.
Before implantation? it is not protected because it will not be covered by the term abortifacient. So it will not be an abortifacient if the ovum is destroyed, the fertilized ovum is destroyed before implantation. I do not see that in the law. Don't you think this definition is very restrictive, or do you think this is a fair definition of an abortifacient?
The law could have...
If it destroys the fertilized ovum before implantation, it will not be an abortifacient?
It will be, Your Honor.
Will your interpretation be supported by this definition?
It appears not, because what the law says is prevention of the fertilized ovum from reaching the uterus, to be planted in the uterus. But what you're saying, Your Honor, is a destruction mechanism before the zygote reaches the uterus. Of course, they can say that that is covered by that definition in the law, Your Honor.
Because the law, to be clearer, should have simply said that an abortifacient is one which destroys a fertilized ovum, and that's it.
That's clearer, Your Honor, I think.
Okay. I think we should find out the intent behind this provision of the law, which does it really outlaw or consider an abortifacient one which will destroy a fertilized ovum before it is implanted?
It should be covered, Your Honor.
Okay. Now, let's go now to the definition of reproductive right. Among others, the law says, to attain the highest standard of sexual health and reproductive health. Now, if you go to the definition of reproductive health, among others, it implies that people are able to have a responsible, safe, consensual, and satisfying sex life. Do you understand what is meant by satisfying sex life?
Well, I have my own ideas, Your Honor.
And that idea may differ from person to person?
Yes, probably in terms of degrees and preferences.
How do you relate the use of contraceptive pill to attaining a satisfying sex life?
I think what the law means, or at least the authors, is that if you have sex without consequences, meaning you remove the consequence of pregnancy, then probably their premise is that you will enjoy the sexual act more.
So it would seem that since the law is directed to the poor and the marginalized, so the pill will enable them to have sex any time of the day and night?
Without pregnancy.
Without pregnancy. So is that a compelling interest? What is the compelling state interest to be served by that?
I don't see anything, any compelling interest, Your Honor.
Will this intrude into the realm of privacy, the right to privacy?
I'm sorry, Your Honor?
Will this provision of the law intrudes into something which is too private and personal?
I think matters of anything inside the bedroom should be off limits to government.
Okay. Now let's go to another provision of the law. This is about the criminal liability of doctors. Let's go now to the criminal liability of doctors. Now, doctors are prohibited from refusing to extend the quality health care services and information on account of a person's marital status, gender, or age, among others.
That's correct, Your Honor.
Will this not impair the doctor's exercise of his profession if he considers the age of a woman to be a factor to consider in providing contraceptive?
Yes, I think that should be a major consideration, but the law will not allow the doctor to have that.
There are studies which would show that young women who have not experienced first pregnancy are under greater risk of
Yes.
incurring illnesses because of the use of contraceptive.
Yes, according to one study, up to 60% risk to breast cancer, Your Honor.
Now let's go now to paragraph A2 of section 23. It says, while it refers to a person of legal age, in subparagraph II, doctors are not allowed to refuse to perform legal and medically safe reproductive health procedures on a minor in the absence of a written consent of their parents or legal guardian. It would seem that doctors are compelled to dispense contraceptives to minors even without the consent, without finding out if the parents or guardian consented to the use of contraceptive. Is that the implication of this provision?
There is a qualification, Your Honor. I think parental consent will not be required if the parent is an accused on an offense against the minor. It says here, parental consent or that of the person exercising parental authority, where the parent or the person exercising parental authority is the respondent, accused or convicted perpetrator, as certified by the proper...
That is under the first sentence, but you go to the next sentence. In the case of minors, the written consent of parents or legal guardian, or in their absence, persons exercising parental authority or next of kin, shall be required only in elective surgical procedures.
Yes, Your Honor.
And in no case shall consent be required in emergency or serious cases, as defined in the law.
Yes, Your Honor.
So, barring any of these exceptional circumstance, there is no need for proof that the parents or guardian consented to the use of contraceptive by minors.
Yes, I agree, because the provision speaks of elective surgical procedures. So if the minor only wants a condom or a pill, it seems like the healthcare provider will have to oblige.
Okay. I have no further question.
Justice Del Castillo.
Counsel, let's just go back briefly to sex education. It would seem to me that you're objecting to this provision because of the mandatory nature of Section 14 as far as public schools are concerned. What if we do away with this mandatory nature? It becomes now optional. I know you're worried. It would seem to you, maybe you're worried, Catholic parents may be worried that because of the moral ascendancy of the teachers over our children, they're vulnerable. So let's make it optional.
If it's exclusively optional?
Yes. Would that be more acceptable to you now?
I think that would be acceptable, because any parent, regardless of whether he or she is a Catholic, can opt out, can choose not to allow their children to undergo sex education.
And if we also apply that to Section 8, the duty to refer to a health facility, we do away with a penal sanction. Would that also be now acceptable to you? No more fine or imprisonment. Or maybe let's make it administrative sanction. Would that be a...
If there will be a penalty that will infringe religious freedom.
That's why. Let's now... well, would an administrative sanction be more acceptable to you?
No, Your Honor, because again, it will impose a burden on the exercise of religion.
It would seem that by referring a patient to another health facility, you would be complicit to something
Yes.
which is against your religious belief. That's what you're saying.
That's what,
Let's
that's
go
what
away
we're
with
saying.
it. No more penal sanction. Would that be acceptable to you?
Well, I think that's better than having sanctions there in the law.
Okay. Thank you, Counsel.
Thank you, Your Honor.
Justice Bernabe.
Okay. Counsel, under the RH law, what is the public interest that the state seeks to protect?
The Congress, during the deliberations, has always referred to as one of the principal interests the aim to reduce maternal deaths. And I think implied in the law itself, considering that about 80% of the law is about contraception, the aim to control population as well.
All right, but now you claim that the RH law violates the freedom of religion, and of course this is on the aspect of the free exercise clause. And the free exercise clause has two parts: the freedom to believe, which is absolute, and the freedom to act on one's belief, which can be regulated by the state. So you are referring now on the freedom not to act, which refers to the act of referral by a conscientious objector of a person seeking care to another facility or to another healthcare provider.
That's correct.
Is that correct?
That's correct.
Now, you also said that the act of referral violates the free exercise clause because you are effectively leading another to commit a serious sin.
That's correct, Your Honor.
Okay. Now, what serious sin are you talking about?
We're talking about the belief among Catholics, and it's in the church teachings, particularly Humanae Vitae, that artificial contraception is intrinsically evil and immoral. And therefore, to be part of contraceptives would violate that Catholic belief.
Okay. But isn't it true that the act of referral merely provides information or access to family planning services to enable a patient to have an informed choice or decision?
Yes, the problem is the conscientious objector participates if we believe that contraceptives are bad. It does not matter if we do it directly, which obviously is a sin, or we lead another person to commit that sin. Material cooperation is something that prevents us from doing that because of our belief that it is intrinsically evil or immoral.
But the patient still have to make a choice. Is that right?
It is not about the patient, Your Honor. The free exercise ground that we raise is from the point of view of the conscientious objector.
Okay. Now, would you agree that physicians usually make referrals if a particular medical skill or ailment of a patient is not within their medical competence or specialty?
That's correct, Your Honor.
And this is, of course, a common practice among physicians.
Yes, Your Honor.
Now, would you agree that the act of referral is a performance of one's duty to provide information or access to family planning services?
Outside of the law, Your Honor, if we discount RH law, there is no such duty with regard to reproductive health services. It is only this law that imposes that. The problem is, if you are a conscientious objector, it will require you to violate your own beliefs. That's what makes it objectionable, Your Honor.
If you're a skilled health practitioner, and this is one of your duty, and your religion prohibits you from doing it, don't you think this skilled health personnel should just resign from his work? rather than taking a job that his religion prohibits him from doing something?
That's what's wrong with this law, Your Honor. It makes the conscientious objector choose either of two things. One, obey the law and in the process violate his own faith, or obey his faith and face the consequence of fine or imprisonment. That's precisely what is objectionable, the creation of a burden in the exercise of religion.
And you believe that the act of referral is very intrusive and burdensome, and it does not cause simply a mere slight inconvenience?
No, Your Honor. Our teachings say it is intrinsically immoral, and a person who participates in the commission of that sin commits a grave offense. That's the precise term used in the Catechism of the Catholics.
Okay, can we go to the freedom of speech and expression?
Sure.
What is the rationale behind the guarantee of the freedom of speech and expression? Is it not the rationale is to have a robust marketplace of ideas?
That's correct, Your Honor.
Now, if the conscientious objector prevents the dissemination of information on family planning and reproductive health care services by reason of his ethical or religious conviction, doesn't he contradict the very rationale of the freedom of speech and expression?
No, Your Honor. In fact, in the U.S. case of West Virginia Board of Education versus Barnett, which has been cited by this honorable court several times, it says that the freedom to speak out what is in your mind includes the freedom not to speak that which is not in your mind. In other words, it's part of your freedom to express your thoughts. Not only the freedom to say it, but also, more so, the freedom not to say something that is against your conscience.
Now, under Section 5.23 of the implementing rules, the conscientious objector who is mandated to refer may still provide messages of disclaimer, like he can always explain his thoughts after the very act of referral, or he can put posters or advertisements that communicates his position. Is that correct?
I think, yeah, it's in the implementing rules.
Now, by doing this, the conscientious objector really dissociates himself from the position that he does not believe in, right?
Not necessarily, Your Honor. I think these requirements imposed by the IIR create a burden similar to what is created in the law itself, because it imposes certain duties, the performance of which will violate his faith.
Would not this association make it fall beyond the mantle of the protective speech?
If it's the association that's doing it, Your Honor, then there will be no instance of the exercise of religion. But individually, I think it will still be a burden violative of free exercise if that rule will impose a condition on the conscientious objector to do certain things, which by doing, he will violate his faith.
And you call that a practice of religion?
Yes, Your Honor. Free exercise.
Okay. Thank you, Counsel.
Thank you, Your Honor.
Justice Perez.
I see two contradicting positions within the law itself. First, the one you presented, which is the fact that contraceptives or the use of contraceptives to prevent fertilization is massively promoted, supported, financially especially, and there is even created a whole bureaucratic infrastructure to implement the objective of the law, which is not specifically stated. In fact, there is even a provision on a congressional oversight committee to see to it that all these objectives towards contraception and prevention of fertilization especially among the poor and the marginalized, which is specified, is achieved. And the DOH is even mandated by law under pain of criminal sanction, of penal sanction, to see to it that up to the barangay level, all the objectives of the law are carried out. In the light of these main provisions, I can say main provisions of this law, what meaning does the two provisions priorly mentioned a while ago concerning the freedom of choice of the mother, whether or not to resort to contraception, and the statement which says that this is not something which is related to birth control because it does not concern itself with that phrase related to birth control, which is the result of one over the other. Is the provision, or are the provisions on freedom of choice and specific mention that this is not a birth control measure, remove all the objectionability of the propagation, massive support, etc.? Or does that main function of the law render empty the provisions regarding the so-called freedom of choice? I wish that such interrelation between the provisions itself in the law, provisions themselves in the law, are discussed.
Your Honor, yes, there are provisions that say that a woman has the right to choose whether or not to use contraceptive. That is in the law. But what we're objecting is this: the state coming in to initiate, promote, distribute, using and harnessing its entire machinery for this purpose. May I use an analogy, Your Honor, if I may?
What I'm saying is, does that, the main, your main presentation about what the law is all about, render empty the message of pre-choice? In other words, it's as though it's not stated there. Those are just, concessions to the conscientious objector of the law.
Yes, I agree, Your Honor.
Request that some thing of that sort, or discussion on those points be included in your memorandum. Also, I thought I heard you say that your objection against contraceptives is because it is harmful and therefore it is violative of that phrase or that constitutional provision which requires the government to promote the health, etc. Is that the only objection that you have against contraceptives because of its side effects? Or is your objection the fact that these contraceptives is being massively supported, massively propagated, massively financially supported, etc.?
Yes, that's the main point, Your Honor. Okay. The fact that the state has intervened, has stepped into the action, and assumed the role of, if I may use, even pushing the contraceptives to the population, contrary to its obligation and duty under the Constitution to protect the health of the people.
And the side effects of the contraceptives is only a side effect. It's not the main reason why you are objecting against that provision of the law.
That is one of the reasons, Your Honor, because it exposes 25 million women of fertile age to the risk of complications and or increased risk for different types of ailments.
I mentioned that because I don't think there is any chemical formulation or medicine which does not have any side effect.
Yes, the only difference...
and it injures at the same time.
That's correct, Your Honor, except that we're talking of contraceptives which are not medicines. They are not intended to cure. They're only intended to prevent pregnancy. If there will be an incidental benefit, like what Congress mentioned, it is purely incidental. That is not the purpose of a contraceptive. A contraceptive serves only one purpose, one aim, to prevent pregnancy.
Okay.
Thank you, Your Honor.
Justice Reyes.
Good afternoon, Mr. Counsel.
Good afternoon, Your Honor.
Will you agree with me that at the moment we are almost 100 million in terms of population?
I think so, that's correct.
And likewise, will you further agree with me that from the NEDA's data or statistics, about 58% of the Filipinos belongs to poor and underprivileged?
That's correct, Your Honor.
And about 28% of the poor families are below the poverty line.
Yes, Your Honor.
I'm more concerned on the equal protection clause because that when the Congress envisioned the law, which is the RH law, it had in mind foremost the plight of the poor families. Am I correct?
That's what
foremost
they say, Your Honor.
Statistics-wise, those families who belong to the lowest strata in our society have more children than like us who belong to at least a middle class or a say educated group of
Yes,
families. But according to you, a certain provision of that RH law is violative of the equal protection clause of the Constitution.
Particularly Section 14, Your Honor, on sex education.
Because according to you, the main target of that law is focused on the poor families, and marginalized members of our society.
That's another objection, Your Honor.
Okay. Will you agree with me, Mr. Counsel, that under the equal protection clause of our Constitution, it means that no person or class of persons shall be deprived of some protection of laws which is enjoyed by other persons or classes in the same place and in like circumstances?
Yes, if they are similarly situated, that's correct, Your Honor.
Hence, the equal protection clause does not require the universal application of the laws on all persons or things.
That's correct, Your Honor.
Of course, this is without the distinctions. This might in fact sometimes result in unequal protection.
Yes, Your Honor.
Correct. What the law requires is equality among equals as determined according to a valid classification.
That's correct, Your Honor.
By classification is meant the grouping of persons or things similar to each other,
Yes, Your Honor.
or certain particulars and different from all others in this and different from all others in these same particulars.
That's correct, Your Honor.
Right. Now, would you agree with me, Mr. Counsel, that you and I and most of us here belong to what we call who belong to the middle class, at least to the middle class family?
Yes, Your Honor.
Would you agree with that? And and we are not in equal footings with the poor and underprivileged members of society, especially those who live beyond poverty lines.
Yes, I think that's a fair statement, Your Honor.
So along this point, Mr. Counsel, would you agree with me that the law, which although focus foremost on the poor and underprivileged, does not violate the Equal Protection Clause of the Constitution?
The fact that the law puts an inordinate emphasis on the poor, Your Honor.
Yes, because according to you, there is indeed a violation of the Equal Protection Clause of the Constitution, because the law foremost zeroed in on the poor and underprivileged people, or members of the poor families.
You can look at it that way if we see it from the point of view of having that basic right to life, the right to bear as many children as he or she wants. If that is an acceptable premise, then if you overly concentrate the RH law on the poor, you are in effect discriminating against them, because you will be flooding them with contraceptives, which you will not do for the other groups in the population, in a way that is violative of their equal protection.
But I would like to view this as, in as much as we are not on the same footings, of course we are all, many of us here, or I would say everybody, is educated and belongs to the at least middle class family. And
Yes,
as such, we know our rights and obligations, especially to our society. And as statistics-wise, we know for a fact that many of us who belong to at least middle-class families and educated have less children than those who belong to the poor families and underprivileged. So
That's correct.
would not be under this particular circumstance or situation that the government envisioned this RHB law, that is to prevent the multiplications of people who in the end will be a burden to our society.
That's a sensitive topic, Your Honor, because it might traverse what is unacceptable, which is the equivalent of a eugenics, where, if you recall, in the World War II, during World War II, Hitler thought that the Jews are undesirable. So he started to eliminate them, Your Honor. If that were the intention of the law, I think that would be most unfortunate.
But I don't think that that is not the intention of the law, because the law only prevents the procreations, the untimely procreations. That's why the law states that there is no life yet. So that's why the government is trying its best to spend for the contraceptives and other devices in order to prevent or avoid unnecessary multiplications of populations, because most of the multiplicants belong to the poor and underprivileged. Because it would be a different matter or story if those who will multiply belong to classes like us, the middle class, the affluent, and the like.
I think, Your Honor, the fact that they are poor should not mean that they will have less in life. But the fact that they are poor should not be a reason for the government to prevent their procreation or their growth. There are studies saying that a natural way to control the size of family is through economic progress. When a family progresses economically, automatically there will be a natural desire to limit the size of family. So the solution is to make the poor get out of the rut, for government to help them become like you and me, middle class at least. That way, by natural consequence, they will understand that probably they would need not so many children. But for government to come in and declare and make a judgment that you are propagating too much, too soon, that you are a burden to society, I think is most unfair and violative of the basic equal protection envisioned by our Constitution, Your Honor.
Too realistic, ano?
Yeah, I know, Your Honor.
We look around our surroundings. Nakakaawa eh.
Yes, Your Honor.
Natin that they have no basic necessities in life. They don't even have shelters, no food, no health services, education, etc. And mind you, these people will multiply and multiply because they have no knowledge about family planning. They just want to procreate and procreate. It's because in the end, there might be a possibility that one of the children might perhaps alleviate their sufferings. That's really the most of the mentalities of the people, especially those. I'm not belittling the poor, but I'm just very realistic at this point.
Probably, Your Honor, the solution is to train their children, because if you train their children, they'll learn to earn a living. And I remember in one report by Vice President Binay, he mentioned that a good chunk of our OFWs belong to the non-skilled. These probably are the people that came from the slums, but were able to get an opportunity to acquire some non-technical skills, and now they're earning and sending support to their family, and also adding to the coffers of government. In other words, it's just a question of harnessing these people. According to all demographers, according to Gary Becker, a Nobel Prize winner, human capital is very important for the existence of a country. And that's the reason why Detroit, one of the reasons, key reasons why Detroit collapsed and declared bankruptcy, Your Honor. So it's not a case of the poor being so many, but a case of the poor lacking training and education. That should be the law that should be passed by Congress, Your Honor. Thank you, Your Honor.
Justice Carpio.
Counsel, in the Philippines, as in the United States, the agency that determines whether a drug is safe or unsafe is the Food and Drug Administration, correct?
That's correct, Your Honor.
Now, do you know of any case where a drug company appealed to the Supreme Court claiming that the findings of the FDA are wrong? The FDA said that the drug is unsafe, and the drug company disagreed with that, and so filed a case in the Supreme Court. Do you know of any case like that?
No, Your Honor, but I do know of 4,000 cases filed in the U.S. right now against Bayer and some other companies.
Yes, I'm asking you whether any drug company has appealed the ruling of the FDA on the safeness of a drug, appealed to the Supreme Court.
No, Your Honor, I'm not aware.
And if somebody in the Philippines a drug company will appeal the ruling of FDA here to the Supreme Court, claiming that their drug is safe, contrary to the findings of the FDA, what do you think will the Supreme Court do?
If there is a finding?
No, yes, the FDA said this drug is not safe for consumption. The drug company disagreed and came here. What should be the decision of the court?
I think this court is not a trier of facts, Your Honor.
No,
so
I mean, it's an appeal.
On appeal. If it's appealed based on a pure question of facts, I think that
they appealed on a question of technical findings. They have their experts who say that the drug is safe. The FDA found it to the contrary, the drug is not safe. So what do you think should the Supreme Court do?
Well, I think if the Supreme Court believes that the case is of importance and there is a possible grave abuse of discretion on the part of...
Absent fraud, let us say, it's, as I said, it's on a technical issue. They have experts on both sides.
I think the court may have to defer to the decision of the
Yes,
FDA.
because we cannot determine whether the drug is safe or unsafe on those grounds, correct?
That's
In the
correct.
absence of fraud, we cannot overrule the FDA because we are not competent on that issue, correct, counsel?
That's correct, Your Honor.
Okay. Now, let's go to religious freedom. Did I hear you right when you said that a law passed by Congress which conflicts with the religious doctrine or belief of a group will be unconstitutional as far as that group is concerned because it will violate their freedom of religion?
Yes, if there will be coercive action.
No.
Yeah.
Yes, there will be coercive action.
Yes. If
So
it will force
for example, bigamy and concubinage are crimes under the revised penal code.
Correct, Your Honor.
And there is a religious group that practices bigamy and concubinage, and they will say, no, we don't commit those crimes because that is part of our religious belief. You believe them? Do you think that they are correct?
This honorable court in Escritor appears to have taken that position, Your Honor.
That is an administrative case. Did the court in Escritor say that the concubinage and bigamy will not apply to the members of the Jehovah's Witness?
No, Your Honor, but
No,
there is
yeah.
an implication to that effect here.
But that was not, as Justice Leonen said, that was not a majority rule.
I understand, Your Honor.
So my question is, you still believe that if positive law passed by Congress, conflicts with your religious belief, that positive law is void, unconstitutional, because it violates your religious freedom? That is your position.
That's my position is that if there is a compelling state interest
Yes,
that will trump religious freedom,
So you're changing it now. If there is a compelling state interest,
yes, because free exercise has never been considered absolute. I think no right is absolute. So between the higher interest of the state, like the one in the U.S. case of Dennis versus U.S. or Schenck versus U.S., where the survival of the state was at issue, then obviously it will have to override individual freedoms.
so in this case, in my earlier case where there is a religious group that practices bigamy and polygamy and concubinage is part of their religious belief, they cannot raise the defense of religious freedom against a charge of bigamy.
I think they can't.
They cannot or they can?
They cannot raise that because that is a law that is neutral and of general application.
Okay, supposing there is a religious group that uses marijuana in their religious ceremony, and we have a law here banning, outlawing possession or use of marijuana, can they raise the defense of religious freedom if they use marijuana in the religious ceremony?
They can raise, but I think this honorable court will...
What is your position? Is that, can they raise that on the ground of, on the constitutional ground of religious freedom?
They can, but I think the better judgment is that...
It's not a valid ground.
It's not a valid ground because the act itself is pernicious by its very nature.
Okay. Let's go to responsible parenthood. That phrase is in the Constitution, correct?
Yes, Your Honor.
So that phrase includes the right of a family to determine its ideal size.
That's part of it, Your Honor. That's
Okay,
correct.
and to determine the ideal size, you may have to space the birth of their children, correct?
Correct, Your Honor.
And how do you space the birth of your children? So to do that, worldwide, most people use contraceptives, correct?
Probably, Your Honor, yes.
As long as it does not violate the right to life. From the moment the ovum is fertilized, that's protected already. But if the contraceptive prevents union of the egg and the sperm, that will be okay by text of the law. Of the
By text of the law, you're correct, Your Honor.
Okay. Now, let's go to the RH law addresses the reproductive health of women. Now, you said that it does not address the other diseases like diabetes, cancer, maybe tropical diseases like malaria. And because of that, does that make the law unconstitutional because it does not address other issues?
It makes the law arbitrary, Your Honor, because in terms of
If
degree...
the law is arbitrary, it becomes unconstitutional.
Yes, because that would constitute grave abuse of discretion.
So you are saying that to be constitutional, the RH law must not only address the health needs of women, but also the health needs of other people, like people in the mountain where there is malaria, dengue, etc., to be valid, to be constitutional. That's your position.
Under the Equal Protection Clause, yes, Your Honor.
Under the Equal Protection Clause. Oh, then we will have a lot of laws that we will have to strike down, Counsel. You also said that the RH law will result in aging of the population, and that's one of your objections, correct?
Yes, Your Honor.
Now, to declare a law unconstitutional, we have to find the specific provision of law that is in conflict, a specific provision of the Constitution that is in conflict with the law, and the conflict must be irreconcilable, correct?
Yes, correct, Your Honor.
So, tell me, how will the RH law be unconstitutional on the ground that it will possibly result in an aging population?
There is a provision in the Constitution which says, Your Honor, that the state shall affirm labor as a major social economic force. And if we relate that to our strength in relation to other countries, meaning our population, our young workforce, to control population to the extent that you will limit our workforce in the future, our viability in the future, will violate the particular provision in Article 2.
Okay, so your position is the greater our population, the greater will our workforce be. That's your premise.
Yes, Your Honor.
But isn't it better to have a smaller workforce but highly skilled so that they will be highly paid instead of sending 11 million of our people abroad, leaving their families here? Maybe we can send only 1 million and they will all be managers, presidents of companies. We'll probably get $24 billion a year also. Wouldn't it be that better?
Only for now, Your Honor, but they will also get old and they will die. Who will replace them?
But you don't have to have hundreds of millions of Filipinos to generate 1 million highly skilled managers.
Yes, Your Honor.
Okay, Counsel, that's all. Thank you.
Thank you, Your Honor.
Counsel, you and I have had metaphysical discussions more than 20 years ago.
Oh, yes.
In my past career.
Yes.
And I've always admired your sincerity and the conviction with which you have stood your ground on many issues.
Thank you, Your Honor.
I also share your preference for some economists. And while I do believe in human capital, I see that your line of reasoning goes already to trying to craft a utopian society that has made policy choices that are not impaired by wrong decisions in the past and an unfortunate historical set of antecedents as this country has had. In other words, for all practical purposes, our government actually has choices on what kinds of ills it will address and what kinds of ills it will temporize on, and for the limited resources that it has to choose which to focus on. Now, this court is not the decision maker on the resource allocation that must be made by government. Do you agree with me on that?
I agree, Your Honor, but What we have come here for is not to question that wisdom or exercise of wisdom. What we're saying is that this honorable court has the duty under Article 8, Section 1, to determine whether, in the exercise of the discretion, Congress has violated the Constitution. That's all we're asking, Your Honor.
But when you're trying to juxtapose the philosophy on the primacy of labor and your reading of culture, of religious beliefs and everything, you have basically said that in the plethora of choices that are available to government, they had chosen one that offends and one that does not uphold other values that can be found in the Constitution. On the other hand, you agree that, of course, the right of parents to be responsible and make decisions on a fundamental matter as the size and timing of their offsprings is also of paramount interest to the state. You have basically decided that your path of a completely natural method that does not also promote an alien lifestyle, because you keep on referring to the United States culture as not compatible with Philippine culture. A way of life that chooses only natural means of family planning, that does not promote an alien culture, that continues to hope that somehow the masses of the poor will be able to find a savior among their ranks so that their families can be saved and be brought to the middle class. And you are projecting that it is therefore incumbent upon the state to ensure that this more natural means of progression, in fact a utopian kind of progression, is the one that is chosen. Is that the sense that we are getting from you?
Your Honor, you're right. Congress has many choices. Whether to accept one approach and discard the other, that's their choice. But the one thing that they don't have any choice is to violate the Constitution. And that's what we're saying. Now, with regard to the kind of family planning method a person would like to take, that is very personal. Even the Catholic Church respects free will. What we're objecting is a situation wherein the state, which under the Constitution is required under duty to protect the health of the people, is the very first to expose the population to the potential hazards of risk. In other words, the state, instead of protecting, is actually exposing the people to potential harm. I call it institutionalizing risks. And that is not the business of government, Your Honor.
Counsel, everything in life has a risk. In fact, the entire legal structure is founded on definition of risks, defining acceptable risks, weighing risks, and attributing liability for when risks are unduly taken when they should not have been. Is that not correct?
That's correct, Your Honor, for an individual. For a state, Your Honor, in case of risk, in case of doubt, because of the obligation to protect the health, shouldn't the state err on the side of caution by keeping a hands-off policy with regard to these issues and leave it to the individuals to decide for themselves? That's our point, Your Honor.
If the state says that part of the prevention of the risks arising from maternal mortality, which includes a long-term view, meaning the long-term viability of a healthy life for a female who keeps on bearing children, is part of the equation. Is that not the right of the state to weigh, meaning the executive and legislative branches of government? And it is not for us to meddle into the facts and try to find the kind of risks that they should be allowing or agreeing to allow.
Your Honor, I think whether or not a woman will use contraceptive is a very personal thing. It is like the state invading into the bedroom of that woman. And I think the choice...
Excuse me, not the bedroom. Mr. Counsel, contraceptives are usually taken before the medicine cabinet, right?
Right, but
Okay.
they do it for a purpose inside the bedroom, Your Honor.
Well, whether they will have sex or not, sometimes it doesn't happen.
Yeah,
the
you're
woman
right.
just has to take it. Okay? So, when we talk about the right to privacy, let us be very clear and try to be clinical about it. The right to privacy on what happens in the bedroom is one thing, but the right to maternal health is another. Now, the state is saying we have chosen to prolong the life of the woman and give her a more viable life, productive, economic life, by allowing her the option to choose a method of contraception that is compatible with her beliefs. What is religiously coercive about that?
Not religiously, Your Honor, but
No, but you have centered your entire
Yes.
argument on religious freedom.
Yes.
Now, I personally know many Catholics who do not believe that it is a sin to take contraceptions. Am I not, in fact, as a judge, intruding into her decision of what is violative of her religious freedom when she believes she can continue to be a good Catholic and take a contraceptive pill?
Your Honor, women who profess to be Catholics and yet believe that contraceptives are okay are not really practicing Catholics. They're not the ones who determine what the Catholic faith is. Because otherwise, any Catholic can simply decide how a particular faith, how the Catholic faith will be applied. I think there is an inconsistency. Because if we say we refer to Catholic faith, we refer to the doctrines, we refer to the teachings of that church. If any person claiming to be Catholic disobey or goes against that teachings, how can he ever say that he is really a Catholic? How can one say that he is Christian and yet not believe in Jesus? How can one say he is Muslim and does not believe in Muhammad? It's a contradiction in terms, Your Honor.
Okay. Now, if you are basically saying that those who choose to take contraception and who believe that they are not violating their religious faith by taking contraception are actually not genuine in their faith, then you're basically saying that you're arguing only from the doctrinal portion of the Catholic population.
Yes.
Is that now your position?
That's correct. Petitioners are speaking for the true Catholics, those who have deeply held beliefs under the Catholic Church.
Okay. Would you have an idea how many % there are of those Catholics who strongly believe that taking contraceptive pills is a sin?
Probably these statistics would not be important, because what is important is what is in the heart of that Catholic, whether he believes that the magisterium and the teachings of the church are what constitute the faith of the Catholic Church. Then that matters, not the number. So in other words, I think, Your Honor, it's not a question of quantity, but the quality, the sincerity of these people, in really believing in the central beliefs of the Catholic Church.
So the strength of your petition, counsel, is dependent on the doctrinal truism with which you hold on to the magisterium.
Yes, yeah, that's correct, Your
And
Honor.
all others who disagree with you, the Catholics who call themselves Catholics but who disagree with you, are basically not correct.
That's what we're saying, Your Honor.
Even if they believe that their religious freedom is not being violated by the RH law.
The problem, Your Honor, is that whether that claim of religious freedom is deeply held and based on a central belief, the fact that they're violating the beliefs of the church will tell me that they are not holding deeply held beliefs.
Are they in sin or are they in ignorance, counsel?
Based on the catechism, based on the Catholic teachings, they would be in sin if they use contraceptives, Your Honor.
So you are basically saying now, if we choose to observe and respect the freedom of conscience of the Catholics, of the population who consider themselves as Catholics even though they take contraceptive pills, as against those who believe that it is a doctrine, a basic doctrine of the Catholic Church, that contraceptives is an evil. Okay. Are you not therefore arguing that your position is only for those sectors of your population that hold on to that particular... and therefore, counsel, if that is so, does it say that one who is a fervent Catholic is compelled to accept artificial contraceptives?
If he believes in the faith, yes.
Where in the law? Because now I am now being forced to narrow my examination to protect the rights of very doctrinal Catholics. Because you have already categorized those who believe that contraceptives, artificial contraceptives, is not a sin, or they are not genuine Catholics, so now I'm going to focus my examination on the genuine Catholics. When are doctrinaire Catholics being coerced to take artificial contraceptives under the law?
Section 7, Section
How?
23.
Can you please read Section 7? When?
Section 7 says, Your Honor, I will go direct to that portion of the provision that infringes free exercise, Your Honor, if I may.
Yes.
It says here, the last second to the last proviso, that these hospitals shall immediately refer the person seeking such care and services to another healthcare facility. And then a similar provision can be found
Okay, let's read it so that we can take it fully and understand that if we are going to operationalize this law, it really means what you are trying to tell me it means. Okay? You're basically saying that all accredited public health facilities, okay, shall provide a full range of modern family methods, including consultations, supplies, procedures, and including services for those who are having infertility issues. Okay? But there is a proviso that even private health facilities, so this is the second part, I'm reading after the proviso, the first proviso. Family planning services shall likewise be extended by private health facilities to paying patients with the option to grant, except in the case of non-maternity specialty hospitals and hospitals owned and operated by a religious group. So that is the first. How many hospitals, private health facilities are now being operated by the Catholic Church?
I'm not sure about the number, Your Honor.
But they would number in the hundreds?
I can't hazard a guess at this point, Your Honor.
Okay, so that they are basically being asked, if they object, then they go to the next proviso to the proviso. And the proviso to the proviso says what, Mr. Counsel?
That this private healthcare facility, acting obviously through its people, will have to refer the person seeking reproductive health services to another
health facility. Okay, so the scenario is this. Someone will go to a hospital operated by the Catholic Church and is asking for family planning services, instructions. And the triage nurse, for example, this triage, I guess it's the triage nurse, informs this would-be patient that only natural family planning methods are available. Is that what the scenario here?
That could be a scenario, Your Honor.
Okay. And therefore, if the would-be patient says, but I want a modern method, can I not have the benefit of information and access to a modern method? Can the triage nurse not say, please go to this hospital, to X hospital? Is that a violation of a religious freedom, Mr. Counsel?
Yes, Your Honor.
Why? Why can that triage nurse, speaking on behalf of the hospital, not simply refer it to another hospital? Does it say that the triage nurse is prohibited from saying, if you use modern family planning method and you are a Catholic, you are committing sin? It doesn't say that.
It says in the Catechism, Your Honor, if I may read.
Okay.
It says here, anyone who deliberately leads others to commit serious sins himself commits a grave offense. That's one provision in the Catechism. There's another provision, Your Honor, if I may. It says here, to the question, do we have responsibility for the sins committed by others? The answer in the Catechism is this. We do have such a responsibility when we culpably cooperate with them. In other words, applying the concept of formal cooperation or material cooperation as implied in these two rules, that conscientious objector will actually commit a grave offense if he refers that person to another healthcare facility.
Okay. Can that person not say, the law requires us to provide you information on another healthcare facility? And the triage draws up a list of other health facilities. Is that a sin?
I think so, Your Honor. Because that would be leading him as well to commit a sin, following this
So
doctrine.
you are leaving basically the triage nurse under the Catholic doctrine only two choices. To keep either completely silent or to say and rebuke the person, but you are committing sin.
No, he
If you are going to ask for a modern family planning method. Is that what a conscientious Catholic would do under the situation?
She could or he could just keep quiet, Your Honor. There is no law that will compel him, other than this RH law, to promote or speak up about contraceptives because, as I said, it will violate his religious faith.
So you are saying that in the situation of Section 7, the only way that the personnel of a private health facility can uphold his religious freedom, his religious belief as a Catholic, is to keep quiet. And the fact that that person is being forced to keep quiet because of Section 7, that is a violation of religious freedom.
Yes, if he keeps quiet, he'll be liable under Section 23, Your Honor. In other words, sorry.
Okay, so we jump to Section 23. Okay, kindly read the relevant portions that you are referring to.
I refer, Your Honor, to Section 23A3.
Okay.
It says, refuse to extend quality healthcare services and information on account of the person's marital status, gender, age, religious convictions, personal circumstances, or nature of work, provided that the conscientious objection of a healthcare provider based on her ethical or religious beliefs shall be respected. Well, however, this is the
This is an objectionable portion for you.
Yes, Your Honor.
Okay.
The conscientious objector shall immediately refer the person seeking such care and services to another healthcare service provider within the same facility or one which is conveniently accessible.
Now, in the principles on the drawing up of the guidelines, the law is very careful to ensure that the freedom of belief is followed. If the IRR allows the conscientious objector, the conscientious facility provider, for example, to not even be forced to refer, will that already cure the problem?
I think so. That will remove the infirmity.
Okay. So the important point is that the conscientious objector not be forced to refer to any healthcare facility, regardless of whether or not that facility might even provide the same kind of advice that you have.
Yes, sir.
What if that healthcare facility refers that person to just another Catholic healthcare facility?
Yes,
will that not be also compliance with Section 7 and Section 23?
You mean the third healthcare provider eventually?
Yes. And
Okay.
then, in other words, does it say that all healthcare providers be listed? Can the conscientious objector not just choose to just also refer them to the inquirer to another Catholic healthcare facility? Can that objector not do that?
Not to refer him?
No, refer that inquirer to the another Catholic healthcare facility.
No, that will be part of the objection, Your Honor. The law accepts
The objection is the fact that you are required to refer, regardless of your idea on what kind of advice will be given by the referred to facility.
That's correct, Your Honor. Because it's like leading him to sin. Remember, the basic premise is that contraceptive is
It's a sin.
inherently immoral
Because
and evil.
the idea is because that inquirer is looking for advice on the use of artificial methods.
Yes,
That's
Your Honor.
it.
Yes, Your Honor.
Okay. So it is the fact that you are going to advance the cause of artificial contraception in any manner, including the reference to another facility that is objectionable from the Catholic point of view.
That's correct, Your Honor.
Okay. So if this is mitigated or tempered by the IRR in such a way that those who you consider as genuine Catholics are not forced to refer, that will cure the infirmity in the law.
But the law is still
No.
there,
Only
Your
with
Honor.
respect to 7 and 23.
If the effect of the IIR is to overturn the enabling law, that would be okay, Your Honor. But if it's just the implementing rule, but the law itself requires the duty to refer.
No, but the law has a lot of provisions there which are very respectful also of the freedom of conscience of persons here. Everywhere it says that coercion is never going to be used. So the IR can look at this as a coercive measure and it can very well provide a way out. Will that cure the situation?
The law is still not cured, Your Honor. That's a problem, unless they amend it. But if it's just through an implementing rule, there is still a doubt as to whether or not the implementing rule can amend the provision of the law itself.
Now, this is in connection with, this is not really my question. I just want to clarify something also in Section 23. Can you please refer to A2II. 23A2II. Okay?
Okay, Your Honor.
A2 is premised on the performance of the legal and medically safe reproductive health procedure on a person of legal age. Right?
Yes, Your Honor.
And there was a comment earlier by one of us that actually even procedures are going to be performed on minors because of II. Do you not think that II is subsumed by 2, which requires that the procedure be conducted on a person of legal age? In other words, we can consider II as a surplusage, but it does not give a separate ground for invalidity. Is that correct?
That's correct, Your Honor.
Okay, that's a correct interpretation. Okay. Now, in connection with the Equal Protection Clause, I have yet to look and find any case in the world that says that when the state is unable to address all medical problems simultaneously, then the state has run afoul of the Equal Protection Clause. Because I've tried to look closely at the proposition that you are forwarding. Is this really something that you continue to hold on to? That all the medical problems of the poor are to be attended to equally, including the medical problems of the rich, because you mentioned diabetes. Is it something you still continue to hold on to?
As a basic premise, Your Honor, if we concede that all men, all people have the right to life and the right to health, and if we assume that the state exists to make sure that all who enjoy the right should be treated the same way,
Okay.
then there could be a problem if Congress would choose to cherry pick, and having done so, would do so in a very obvious way that you see that the serious problems are not taken care of, while the not so serious problem are taken care of. I think that's what we're saying here, Your Honor, that you have a situation wherein the government would pour in billions of pesos. And if the idea is to prevent or reduce maternal deaths of 160, which is less than 1%.
You are already entering the question of wisdom, correct? And this court is not the representative of the people. It is there in Congress where more than 200 representatives in the lower house and 24 in the upper house debate day in and day out, claiming representation of the people. We do not claim to be representatives of the people. We only abide by what we see the Constitution to provide for. And in that sense, therefore, we're able to guard the rule of law even against the dangers of populism. But what I am saying is that wisdom, which you are already tracking us to, is a prerogative of Congress, and that has never really been set aside. Unless now you are going to arrogate unto us the role of a super body.
The principle of equal protection, Your Honor, is written in the Constitution.
Yes, so equal protection. Try to look for a situation anywhere in the world, anywhere in history, where a court has ever compelled the state to attend equally to all needs.
What we think, Your Honor, is Congress...
Even the richest country in the world cannot even do that.
Yes, but they probably would start with...
What more a country like us? So the solution is get more people who think like you elected into Congress so that the right priorities can be set as you see fit. Correct? But it is not up for us to cure the problems that you see that Congress has generated by choosing one priority over another. The solution is to elect the people who you think represent the correct values.
Yes, but that is only one of
That's
many
a political
objections,
solution. That's not a legal solution.
Yes, Your Honor, but again, I submit that it is the duty of this court to be able to ascertain
But
whether...
how can we choose over diabetes, a cardiovascular disease?
No. We're not asking this court.
A lung problem.
We're not,
and another health-related measure, because they're saying that this is a health-related measure. They even use the word health. So if it says it's a health-related measure, how can we say that the health-related measure that benefits us, justices of the Supreme Court, who have many of those diseases that you were saying should be attended to, should receive preference over what Congress has said is a more important health measure?
I think it's basic in the exercise of checks and balances for this court to be able to look into the arbitrariness of particular legislation. But going beyond that, Your Honor.
Okay, arbitrariness. Now this, I am very curious. How can you raise arbitrariness if this has been debated for 14 years?
You know, the fact that it has been debated...
Arbitrariness have something to do with something being plucked out of thin air.
Or
something that has interjected itself artificially into the timeline of the natural course of events in an institution. But if something like this has been germinating in Congress for 14 years, it is difficult for me to just come in and say, Congress has arbitrarily exercised its powers. They must have already had more permanent enemies with each other for all these years, and they have fought long and hard over this. It's difficult for me to say that they were arbitrary. So why are you saying that there is arbitrariness? And you've had many of the lawyers and litigants of your side have actually participated in the debates in Congress. The outcome is something that we do not control. So how can you interject the argument of arbitrariness?
Arbitrariness can also arise if Congress, in the exercise of its legislative power, would actually, as I said, cherry pick to a point where
what is cherry picking? Can you tell me how people cherry pick? Oh, let's imagine
This is-
cherry orchard. Okay. What is cherry picking?
Cherry picking in this
So that
particular
it becomes
instance,
legally relevant.
it becomes relevant if
Yes. Is it similar to a lottery?
probably for them,
So it was lottery that
No, no.
attended 14 years of debate.
what we're saying is something like this, Your Honor. The law will require the disbursement of at least 3 or 4 billion pesos. And it's a given that we have limited resources.
How much did the Pinoy, with all due respect, the President, announce would be the budget he was going to submit to Congress?
I think it's something like in the trillion.
2.3 trillion. Okay, 3 billion. 3 billion is a fraction of 2.3 trillion. Can you compute, please?
3 billion.
It is a little over 1 over 100. Or even 1 over 1,000. Okay. 14 years of debate. 3 billion budget. In a 2.3 trillion national budget proposal. How can you make the case for a lottery type of decision?
By looking at it from a different perspective, Your Honor. With 3 or more billion, you can build a lot of hospitals. You can train more poor people. You can actually provide free medicine for tuberculosis.
But all of those, I heard it in the SONA yesterday. A lot of hospitals were going to be built, a lot of schools were going to be built, a lot of healthcare facilities and healthcare services were going to be expanded. So you cannot say that of all the medical needs of the population, this received priority over the others. I didn't see that in the figures unless there was magic in the President's PowerPoint presentation.
Yeah, I agree that he will build more hospitals, but with 3 or 4 billions or even more pesos, that would add up to the hospitals that will be built. The point, Your Honor, is that if you have limited resources, if you have a budget in the House, wouldn't you prioritize?
But I thought that a budget bill is basically a bill of priorities. So the GAA, if it contains 2.3 trillion, already has priorities. And the only way you can really argue that this RH law is an arbitrary, cherry-picked, lottery type of allocation, if you can show disproportionality in the budget allocation for other health services and other health facilities and other pro-poor facilities vis-a-vis what is going to be given to the RH law. That is the only way you can do that. Because your statements of the lack of arbitrariness also is related to a question of an attempt to say that there is a lack of proportion. The means that the government has chosen is a sledgehammer type of legislation that goes through a massive information campaign, targeting the wrong sets of people, giving the wrong sets of solutions. On the other hand, the correct solutions are being completely ignored. Your earlier statements actually indicate to me that you think you could have done and crafted a better budget proposal than the President's team, because you would have made a better allocation of the budget for the poor. But yesterday's 1 hour and 45-minute speech actually enumerated a lot of his supposed intentions to provide services to the poor. Do you think that there is not a lack of balance in the way you are phrasing the issues here?
Your Honor, the 3 or more billion pesos, I think, would be in addition to what the DOH will provide in its general appropriation. In other words, our point is that is one of the many issues that affect this particular law. We also raise constitutional issues that they will have to overcome.
So you are now going to abandon this line, because I am happy if you will abandon this line, because I don't think you can prove your point here. You want to go into a debate on the proportionality of the attention to the RH law vis-a-vis the other kinds of services. You're in. You're going to go into a hornet's nest that you cannot extricate yourself out of. You'd better just go back to your original discussion on religious freedom. Okay? So, let's go again to religious freedom. Justice Telly has already told you that there are several portions in the religious clause of the Constitution. Now my worry, because you are basically saying that it is the doctrinal portion of the Catholic Church that is very strongly against this, on the argument that this is a violation of the Catholics' religious freedom, is this not already skirting on state interference with the secular state, religious interference with the secular state policy, really in danger of infringing the non-establishment clause?
Your Honor, our objection does not fall under the non-establishment clause, which guarantees equality between believers and unbelievers. We're talking of the second part, which is the free exercise. We're saying that Section 7 and Section 23A3, because of the coercive nature, imposes a heavy burden on the exercise of our faith.
Okay, let's say we assume just for now we're able to cure 7 and 23. Okay, let's go to your equal protection problem and your religious freedom problem with sex education in schools.
Yes, Your Honor.
Okay, you're basically saying that the poor are going to be, because they go into public educational institutions, are going to be discriminated against because, first of all, they will have a heavier burden.
For the students.
For the students. Can you go to the section of the law that provides for sex education, please?
That's Section 14, Your Honor.
Okay, let's go there. Okay.
The state shall provide.
You had been saying they will be coerced. Your religious freedom proposition went like this. They will be coerced, unlike those in the private schools, because they will have to go through this. 14 only says that the state shall provide the education. Where does it say here that if the parents or the student objects to the provision of sex education, they cannot opt out of their classes? Where does it say in 14?
In the last sentence, Your Honor.
Okay. Provide a curriculum.
Which
there are elective portions of curricula and there are non-elective portions of the curricula. Does it say that this is a mandatory portion of the curricula?
I think it does, Your Honor.
Why?
Because of the use of the term shall be used.
The shall is a formulation. The mandatoriness of the curriculum is not related to the formulation. The formulation is mandatory on the part of the DepEd, but whether it is coercive on the part of the students to have to enroll in such classes is not provided for in Section 14.
I think it is.
How?
It says here, shall be used.
Oh, so the DepEd can use it. But
yes.
What I'm saying is that if a student does not wish to attend this class, can he not refuse to attend this class?
He will fail. Because it's integrated. It's integrated in all the subjects.
You go to the middle portion, please. Okay? Provided flexibility in the formulation and adoption, even adoption of appropriate course content, scope, methodology shall be allowed only after consultations. In other words, there is a prohibition on the part of the state, on the part of the DepEd, to implement anything that has not received the consensus of the community. We have had so many curricula where students can opt out. We even have home-based education. I don't think the DepEd will be as arbitrary as to say that you will fail if you refuse. Your children will fail if you refuse to allow them to attend sex education classes. I don't see coerciveness here. I see a policy direction given to the DepEd and a formulation of a process by which the DepEd can implement that, which is only after consultations have taken place.
If that will be the interpretation of this honorable court, then I think it will help make that provision acceptable. If the interpretation of the court is that there is no compulsion and that any parent can opt out.
You know why it's easy for us to interpret it this way? Because everywhere the law is replete with the respect for the freedom of conscience. So we just take that into consideration and we already have an easy way of interpreting Section 14.
If that would be the interpretation, Your Honor.
Okay. Now, does the reproductive health law encourage the failure of regulation by our Food and Drug Administration? Does it? Because he kept on saying that there are so many risks. The information will not be there. Information will not be disseminated. Is there anything in the law here that gives us a clue that that is the intention that is going to be given to the FDA?
Well, there is an indication in Section 10, Your Honor, Section 9.
Can you read it, please?
It says, the National Drug Formulary shall include hormonal contraceptives, intrauterine devices, injectables, and other safe. If you read the text of the provision, it seems to qualify safe. It seems to use safe as a qualification to the preceding enumeration, which means that this law, Section 9, already makes a conclusion.
Okay. In Attorney Noche's argument last time, she considered that conceptually there can be hormonal contraceptives that only take the first two actions and does not fulfill the third action, which is to prevent implantation. Now, we cannot find out among the pills that are there which can perform two actions or which can perform three actions. Okay? We cannot. We're not doctors. We're not biologists. We're not pharmacologists or whatever. We're not chemists. So, if this is so, can you please also read for me Section 19, the DOH, for example. 19 B1 3C Section 19. Okay, let's go one by one. B1 first.
B1.
The DOH. You start with DOH.
The DOH, in coordination with the PHIC, as may be applicable, shall 1. Strengthen the capabilities of health regulatory agencies to ensure safe, high-quality, accessible, and affordable reproductive health services and commodities with a concurrent strengthening and enforcement of regulatory mandates and mechanisms.
Okay. Ensure safe, okay, reproductive health services. You had made much of the point that there are so many health risks that are associated with artificial contraceptives. Now, the DOH is mandated to ensure safety of the users of any method that they are going to accredit. Okay? You go to B3.
B3, Your Honor.
Yes?
Engage the services, skills, and proficiencies of experts in natural family planning, which shall provide the necessary training for all BHWs.
Okay, see, there is no bias that I see against the natural method here. They are required, in fact, to engage the services. They are required to hire experts on natural family planning. So this is not as if there is going to be a mass distribution of pills, because they are required to at the same time engage experts who will teach the people about natural family planning. Now let's go to C.
See,
Also of the same section.
the FDA shall issue strict guidelines with respect to the use of contraceptives, taking into consideration the side effects or harmful effects of their use.
Okay. Strict guidelines. Notice, FDA shall issue strict guidelines with respect to the use of contraceptives, taking into consideration the side effects or harmful effects of their use. This is a statutory duty on the part of the FDA. Earlier, you were talking as if the law wants to destroy the health of women. Now, you have here a very clear statutory duty under the duties and responsibilities of several government agencies on what they must ensure. This is clear. So it is not as if the harmful effects are being ignored at all. In fact, even a painkiller has side effects, even on the liver. Even an ordinary painkiller. The most ordinary medication, maintenance medication that we are taking now, all of us that you admitted, in fact, to taking, all of these have side effects. And the FDA is required to make sure that these side effects are taken into consideration. So the guidelines need to be strictly provided. So I don't see anything in the law that says that we should be insensitive to the consequences of women as long as they do not become pregnant. It's okay, give them contraceptives, even if they get cancer in the process. I don't see that, Mr. Counsel.
Yes, Your Honor.
Not at all in the law.
There
It
is
is the law that we are talking about. So what would I trust? My judgment on the health risks of these drugs on women? Or I would rather trust FDA, before whom you and everyone who believe that contraception should never be provided to the population if they're artificial, you can go there and argue that these are unhealthy.
2 points, Your Honor, if I may.
Okay.
First, Section 9, if it's read on its text, appears to preempt the exercise of discretion on the part of FDA. Number 2, in the U.S., before a physician could dispense a contraceptive, the law there requires certain procedures
So
and
why
examination.
why don't we require that to be put in the guidelines or in the FDA? Why don't you argue that, please, in the prescription, in addition to the other kinds of things that must appear there, you have to provide all of the question and the checklist. In other words, it's like a punch list, a construction punch list, right? Why don't you argue that there be a construction punch list similar that is applicable in this situation?
Because in terms of logistics, in the States they have, because what's required there are skilled, meaning physicians who are actually experts, meaning if you need an OB-GYN, then
So
you'll get that.
let it be there
But
in the
you don't have
guidelines. Let it be there in the guidelines.
Under the law, they will harness midwives, they will train even non-medical people to provide these services. So in other words, in the law itself, there isn't any safety net, there isn't any control mechanism that would ensure the safety of the health of the users of contraceptives.
Go to Section 22.
Yes, Your Honor.
Okay. There is a Congressional Oversight Committee. Congress has been talking about this for 14 years. Why can we not entrust this matter to Congress again? That they will provide for whatever safety net. Because you have been arguing on the fact that this law is not comprehensive enough. There is never any law in the legal firmament that is sufficiently comprehensive to address all ills. And we have never struck down a law because it is not sufficiently comprehensive. Even if they call it comprehensive land reform, they cannot make it comprehensive enough.
We're questioning the law.
For
On constitutional
insufficiency.
grounds.
No, you had argued that it is so insufficient that it must be struck down. I am saying that Section 22 provides you your step forward. We don't have an actual case here. What we don't have here is an actual case where first the FDA's metal has been tested, where it approved as accredited an abortive fashion when it should not have been granted such an accreditation. Okay? We have not had a test case here where there is a health worker that has been trained by the DOH that has provided to be an incompetent service provider. We have not yet had here before us an instance when the Congressional Oversight Committee has even reneged on its statutorily imposed duty of making sure that the safety of women is provided for. We don't have that. In other words, what we have are fierce speculations to go on.
We also have violations of the Constitution, Your Honor.
Well, you have already said that it violates the religious freedom of those who are very strict about adherence to the magisterium. And that is duly noted. How you argued it, we already fully understand how you are arguing it. But what I am saying now is that perhaps you have not seen other facets of the law that provide for a balancing in case there is a lack of a solution to a particular problem. In other words, your arguments have been mitigated. I see Section 22, I see Section 19, I see a way of reading the other provisions that you are complaining about, because I'm going to use as interpretative mechanisms the other policies that are replete in the entire law which tries to protect the health of the mother, and I see that there is a way that these can all be balanced off. What I am afraid of is that you are going to ask us to make a ruling that it is violative of the freedom of religion because the law violates the magisterium. And I'm saying now, where under the Constitution can we draw the line that will connect us to make such a legal conclusion from the magisterium to a judicial decision?
We would just like to clarify that it's not because it violates the magisterium that the Constitution is unconstitutional. It is unconstitutional because it impedes the free exercise of religious rights flowing from that magisterium.
Okay, so if we make a conclusion here that the conscientious objector will have to be found a way out by the government, that will already do away with your argument on religious freedom. Correct?
So far as those two provisions are concerned.
Yes. Okay. With that, I have no further questions. Yes. Okay. Justice De Castro wants to add.
Yes, Your Honor.
I'll go back to Section 23, paragraph A, 2, and II. What, did you say you agree that the provision here about minors is a surplusage? Why do you say that? What do you mean by that? That this is a surplusage here? Are you saying that we will consider this as not written in the law?
Well, this is not
What do you
among.
mean by that?
I don't think this is one of the provisions that we raised.
You were asked whether you consider this as a surplusage, and you said yes. What do you mean by that? You mean to say we will not consider this as part of the law?
Yeah, if there's a way to harmonize all the provisions, that's a basic rule of statutory construction, Your Honor.
On the other hand, don't you think that the term legal age here is the one which is negated by the two paragraphs following that introductory portion of Section 2? It refers to legal age in the beginning of the paragraph, but the subsequent two subparagraphs refers to minors, and the provisions are very clear. Even married couples can be minors as long as they were given parental consent. So even I can cover minors, not only persons of legal age. And subparagraph II refers to minors, clearly refers to minors. How can we say that these are surplusage in the law. These
We
are
submit, Your Honor.
integral parts of the law, which refers to minors. And this prohibits anyone who would require a written consent of a minor who wants to avail of contraceptives or family planning methods. And if you consider that in relation to the other provisions of the law, which says that any violation of this act will be penalized by imprisonment or fine, it would seem that this provision will come into operation if anyone refuses a minor to be given any planning method or contraceptive device because of the absence of written consent. That person can be liable under this provision. And it is not up to us to say that any provision of this law is a surplusage unless we say that this violates the Constitution. That is the only time we can say that this provision of the law cannot be applied at all.
We submit, Your Honor.
Okay.
Okay. We will have attorney. You're excused, counsel, as always.
Thank you, Your
A
Honor.
pleasure. We will have attorney Gana for the next session on Justice Mendoza. What date? August 3, 2 p.m. Afterwards, we will immediately proceed to the Solicitor General and the other respondents.
Your Honor, is it possible for former Senator Tata to give a very short closing?
Please no, let's not vary. We always discuss even the procedures on this.
Sure.
If you want, you can make a manifestation, but we will follow the advisory, and then we will face it when the time comes.
Thank you, Your Honor.
There being no further comment from any of my colleagues, the session is hereby adjourned.
All rise. Please remain in your respective places until the Chief Justice and the Associate Justices leave the session hall.